introduction. Good morning to all of you, and I may start thanking you people for joining this session. Am I audible? Am I visible? My screen share is
Yes,
there?
sir.
Really? Yeah. So basically, today's session is on the role of related parties. Basically, role, we can say that instead of role of relating parties, basically the idea is not to have a role for related parties in the CIRP. So now what we are trying to do is understand this related party concept in a more detailed way. We'll deep dive into the definition and see how in practical terms we have to apply that. So I'm just taking a minute to yeah. So basically, broadly, we'll be covering the concepts of the related parties and concepts which will go deep dive into the definition of related parties, both in terms of Companies Act as well as IBC, and see the differences and how IBC is more strict as far as related parties is concerned. And I have some cases related to related parties which we can discuss. And we also have a small session, a small what do you call exercise where we can do practical application. So now basically we have to see related parties. I'll go into the definition and all that. Before we do into that, basically we need to understand when a CIRP starts, when the related parties have to be identified. So CIRP has to be identified at different stages. These related parties, basically at the time of constitution of COC. So, but the constitution COC, because COC should not have any related party as a member of the COC. So when a claim comes, when the as an IRP we are trying to see the claims and identify, we also need to see if there is any party who is related. Of course, we take a declaration from the claimants, but we also have to see who are the people who exactly what is their what the entity background and all that. We have to see whether they are related in any way to the corporate data. So, so at this stage of constitution of COC is one stage, and second stage is when we call for resolution plans. So when the resolution plan comes, we have to ensure that related parties do not submit a resolution plan because they are not eligible as related parties to they are disqualified in terms of section 29A. We'll go into that. So at that second stage would be at the time of resolution plan. Third stage would be for identification of the preferential transactions, undervalued, fraudulent, and such kind of transactions, extortionate transactions. At that time, we have to see whether the transaction relates to a related party or an unrelated party. So these are some of the things, the various stages where this becomes. So even in liquidation, we have to see at the time of a public auction whether a person who is already not eligible under Section 29A is coming to public auction to buy because they are not permitted to do that. So and so all these things stages we know and we have been trying to identify and practice that.
Excuse me,
Then the next question is who identifies the related parties in a CIRP? This identification of a related party is squarely the duty of IRP or RP because you can't go refer to COC and ask whether so and so is a related party. It is the decision which has to be taken by the resolution professional. And this has been confirmed in different judgments also, even Supreme Court judgments also. It has been confirmed that RP is empowered to decide who is a related party. Okay. So now, who are these related parties? We have to see in detail how it is to be seen and how identification is to be done and all that. That we will go. Before we go into that, I would like to have a small warm up poll, because I am in the next screen. You are able to see there is what I'm asking is IBC treats related parties primarily as. So there are four options. So you can tell me uh, which are the options which you feel is most suitable. I'm just opening that. So whether related parties under IBC are treated as a normal stakeholders, whether they are treated as a suspect stakeholders, or they are passive observers, or beneficial stakeholders.
Suspect.
So maybe somebody can answer or somebody can put it in the
B.
chat box.
B is a suspect stakeholders.
Yeah. Anybody has a different opinion on that? So basically, IBC is very suspicious of related parties compared to Companies Act. Companies Act is more liberal as far as treating related parties is concerned. So now all our presentation will go through and we'll understand how the suspected, the related parties are treated as suspect stakeholders. Okay, now basically we need to understand why there is so much of suspicion on the related parties. Well, how do they affect the CIRP? So the question is, do they matter at all in a related in a CIRP transaction? So now, so related parties. If you have related parties in a COC, or if you allow them to submit a resolution plan, what happens is that related parties are very closely connected with the corporate data. They know, like, what has happened in the last 4 years, 5 years, or 10 years, and there could be related parties. What I mean is the promoter's family is there, brothers, sisters, or close relatives are there. And then there are people who have worked with the company for large. There could be CFO, there could be other people and the marketing specialists and all that, who knows what is the difficulty of this company. And then, and if you have them in COC, they will also try to affect the valuation, how to select the valuer, and what kind of things are there. So the basically the risk is that the value, the basic idea of our CIRP is maximization of value of the assets. That particular objective could be defeated because we are this erosion happens in the value of the company when you deal with related parties. But before we go into the definition of related parties under IBC, I would like to just see how the Companies Act deals with them, because we'll know that the definition of the company, the related parties is basically taken from Companies Act. Most of the, I think, entirely or almost 90% is from the Companies Act. So now, but in the Companies Act, related parties are not excluded from ownership and management of company under the Companies Act. What is the meaning of this? Meaning of this is that in a suppose a board can have a related party, and they can have in a very powerful positions in the company. Only thing is we need to see that whether that declaration they have been declared as a related parties, and for proper resolution is passed sometimes by the board or sometimes at the general body meeting. So once this procedure is complied with, then then there is no problem as far as related parties functioning in the company. So Companies Act is more liberal. They accept that related parties have a role in the company and in the development of the business and all that. So that is the way they agree. But but and there is no penalties are there. But see, when related parties are generally taken more seriously in Companies Act, when suppose there is an auditor is to be appointed, then they very closely it is seen. In SEBI guidelines, if you see connected parties, insider trading for purpose of insider trading also, these connected parties are closely seen. But generally, there are penalties. It is not that they are excluded. And even if you take the approach of the judiciary, it is generally balanced and towards procedural compliance. They want to see whether shareholders are aware of this, and if they are aware and they have accepted it. And once that is done, then it is acceptable. They don't have any serious issues with that also. That is the approach of the Companies Act. And what is the approach of UNCITRAL and what is the approach of UK law? I examined that also. UK law basically, why UK law is important for us is our IBC is based on UK law. UK law was almost 30 years ahead of IBC in India, and then they have a lot of case laws also. And I thought it would be beneficial to understand how the related parties are treated in UK. In UK law, associates, connected persons are trusted to a moderate extent and excluded to a limited extent. In the limited to a extent, in the sense they can be part of the COC. Yeah. And even if they had the courts have a discretion in the sense that somebody says moves the court and say I'm not a related party because of so and so reasons, and the court can give a direction, can decide whether they can see the facts of the case and decide whether that is to be taken as a related party or not. And the related parties or connected parties generally have the same voting rights as other creditors during most of the insolvency proceedings. And especially in the like pre-pack arrangements, what we have, they have a company voluntary arrangement, and there also the debtor is given some role. And the debtor in possession. So debtor is involved in the preparation of the resolution plan and all these things. Whereas that is not the case in our country. And even as far as PUFE transactions are concerned, they are also very strict about it. But their approach is slightly different. It's not as rigid as Indian law is there. So even on UNCITRAL, the base law in which we have depended, there also the treatment of related parties is not as strict as we have evolved in our IBC. So now in IBC, the difference is that the related parties are excluded. I just mentioned that excluded from the decision making of COC. They are not allowed to submit resolution plans. So they are not part of the DOC. They are viewed with they cannot participate in the COC, and they can also they cannot submit a resolution plan, even if it could be a very genuine party, and it could be the promoter might have defaulted for genuine reasons. But they are all of them are treated with suspicion and are generally barred from any role in the insolvency. And when we look back at the transaction period, what you call fraudulent transactions or all those things, so we have a longer look back in the sense that for 2 years we have to see for related parties, whereas for others we see for 1 year from the ICD. And what about judiciary? Judiciary also, when we go and see the cases, they are not very particular about the form, whether who are the directors in a company, who is giving a resolution plan and all that. They go deeper and see whether the particular appellant, resolution applicant is connected in some way or other. Even if direct relationship is not there, when influence is there, that is also seen. So the basic idea is that what is acceptable in a solvent functioning company is not acceptable once the insolvency happens. So that is the basic thrust, because insolvency resolution is slightly different from operation of a regular company. So, like I said, we have this is different from UK law, though we have based our IBC from UK law. So that is the now. So when we started off, we started with the excluding related parties from COC. There was no disqualification of resolution applicants. Because even the promoter or his close relatives or close friends, they could submit a resolution plan. But what happened initially when this thing was allowed in 2016 and 2017, defaulting promoters began bidding for their own companies. So what is the harm in it? Because in when you go for CIRP and go for resolution plans, it is generally that the bidding is at a very low value. What depending on what is the liquidation value, we try to match. But then what is the claims? If you see the claims, it will be hardly 30, 20%, 30% of the claims are approved under resolution plan. So in this, if this promoters or his relatives or his close friends are allowed, they'll get back the company, uh, and they will avoid all the liabilities, so ultimately the creditors will be suffering. So promoters used to front entities, related parties, friendly funds, and assets were bought back at deep discounts. As a result, IBC was becoming a cleansing mechanism for promoters, not a resolution mechanism for creditors. So these are the some of the, there are at least one case I have where which is prior to introduction of section 29A, prior to disqualification of related parties, where you will see that how the things have been manipulated. So now I'll give you more details about the related parties under IPC. Section 5, subclass 24. That defines the list. It kind of gives a list of parties who are related parties with reference to the corporate debtor and with reference to the individual, maybe a personal guarantor. In case of a personal guarantee case, we have to see the definition in respect of individuals. So the main people who are basically directors, promoters, key managerial personnel, they are all related parties. They are considered related parties. And then holding company, subsidiary company, associate company. These are of a particular corporate debtor. They are all treated as related parties. Subsidiary is, it could be 100% subsidiary or a 51% subsidiary. Associate is generally you have a very good shareholding, maybe 20%, 30%, or even 40% shareholding is there in another company. That company will be treated as a related party to the corporate data. Apart from the ownership, and there is persons in control or significant influence. This also, we have to see how this works in practice, and then we have to identify any particular person who is in control or who is having influence over the corporate data, and such person should not be allowed to be part of COC. And all the relatives of promoters or directors, they're all treated as relatives, entities with common control or management. The definition is intentionally wide to capture indirect influence. So this is what the picture is. So I broadly covered who are the people who are there. And I'm going to give you the definition as per 524 in a chart. You're able to see the chart? Hope this is clear.
Yes, we can see it. That's clear.
Yeah. So basically, if you see, I have first let us touch with the related parties of corporate data. See, I put corporate data here, and the directors or a partner or a key managerial personnel of the corporate data are related parties, and their relatives. Again, there is a definition of relatives is clearly defined. We'll come to that. So all the relatives of these three people, directors, partners, and KMPs, they are all related parties. And then depending on the ownership, I've put on the basis of ownership who are the related parties in this next column. If you see LLP, of course, the director or partner or they are a part of any other LLP, that LLP would become a related party. And if he is a partner in another partnership, that partnership will also be a related party. And of course, private limited company. Private limited company, even with holding as low as 2% of the capital, is also treated as a related party. And then similar is the public related company. Public limited company also, if you have 2% holding, that public limited company will be treated as a related party of the corporate data. And 1, 2, 3, 4, and fifth category on the basis of ownership is that any person in whom the CD controls more than 20% of the voting rights on account of ownership or voting agreement. So if the CD has invested in another company or another entity, any person, any entity, it could be any entity, where 20% vote share is there, then it will be treated as a related party. Then apart from the ownership, apart from the self people who are directly involved, and apart from the ownership, the advice is also one factor which decides whether a related party is involved. So any body corporate who acts on the advice, directions, or instructions of DPM, that is director, promoter, and managerial personnel. So if the manager personnel is in a position to influence any other body corporate, so the question of influence, we have to see how it is to be proved. Any body corporate who acts on the advice, directions, or instructions of any of these people will be treated as a corporate, is a related party to the corporate debtor. I mentioned OCB. OCB is ordinary course of business. Okay. And similarly, any LLP, any partnership, they just body corporate you said, and again it is specifically said any LLP partnership who acts on the advice, directions, or instructions of these people, they are all treated as related parties. So this is on the ownership and advice. And when I come to this side also, who owns the corporate debtor? Suppose a holding company of the corporate debtor is there, or a subsidiary of the corporate debtor is there, and associate company. So if the corporate debtor is part of a big group, suppose, so the entire group will become a related party. Subsidiary of a holding company, sorry, subsidiary of a holding company of the CD. So holding company is there, and any subsidiary of that holding company will also be a related party. Any person who controls more than 20% of the voting rights of the CD on account of ownership or voting agreement. So this is also on the other side. Like if CD can control 20% of another company, but any other company which is controlling the corporate debtor with 20% shareholding, they also become related parties. Any person having more than two common directors. So this is also like, so you have a subsidiary or you have a associate company where the common directors are there. There also it becomes related party. So apart from ownership, the advice. Suppose there are people who are advising the corporate debtor, person on whose advice, directions, or instructions a director or a promoter or a managerial person of the CD is accustomed to act. So again, these are terms which have to be carefully proved. RP has to see how this works in practice. So if somebody, corporate debtor, is dependent, is taking the advice of another company, any person who can control the composition of the board of directors or corresponding governing body, any person who is associated with CD by participating in the policy making process. So he need not be a owner or shareholder or anything like that, but suppose a strong advisor is there and he is participating in the decision making process, then he can be treated as um, a related party. Then moving ahead, say
Excuse me,
ownership
sir.
we have seen, advice we have seen.
Excuse me, sir.
Sir?
How we can find that he is taking the decisions?
This you're talking about the policy making process, right?
Yeah, yeah. But how
Yeah,
we
it's
can
a
establish the related party in case of taking the decisions?
so there could be some record of the like this advisor giving a report or giving any opinion, or CA is giving some opinion how to do it or how not to do, and there could be advocates, there could be consultants. So if there is a proper record and that particular consultant is giving is trying to be a member of the COC, then we have to see that since there is a record. See, I've seen cases where in Phoenix and all that, Supreme Court has NCLT, NCLAT has examined what you call the mails. So somebody has said that this mail is there where this man is marked as a consultant. Decisions are conveyed to him. Advice is taken from him. So there could be mails. There could be proper minutes of the meetings. So all these things, it is very difficult for us to see. But then these are the indicators which we can decide whether a particular person is influencing. So, and then similarly, collaboration. Collaboration is again any person who is associated with the CD on account of interchange of managerial personnel. Again, this in a group is there, somebody who was working another group company, he comes as an MD of this company. Then both the companies become related parties. And there is a case also in this case how this relation, the interchange of personnel is to be seen. I'll come to that. And any person who is associated with CD on account of provision of essential technical information to or from the CD. So even collaborators who have to be seeing, if some claim comes from a person, whether he is a collaborator or whether he is a associate company, all these things matter, because basically the idea is that the definition is so broad. Okay? So now, so it is very careful assessment is required, because suppose you don't treat somebody as a related party, and after some time another claimant or another member of the COC comes and says so and so is a related party, then it will be difficult, because you would have already been a COC member and all that, and how to get him out of the COC is going to be an issue. So this broad definition under section 5 of subsection 24, 524, these are all the items which are covered. So this is a very broad definition. And then 524A has been inserted later, which gives this related parties with respect to an individual. This also, like individual, with reference to the individual, again, we have to see who are the ownership basis, and more or less it is similar, but then a relative of an individual, relative or spouse, where LLP is there, partnership is there, and trustee. This is another important thing which you have to see. Suppose there is a trust which has given a loan to the individual or to the corporate debtor. Trustee of the trust in which individual is beneficiary. The trust is not specifically mentioned in the CD definition, but it is broadly covered. There is another case which I will be discussing where a trustee is involved. So in the case of individual, a trustee, suppose there is a trust and there is a trustee in which the individual is a beneficiary. suppose the individual is a beneficiary, the trustee becomes automatically a related party. A trustee who can exercise powers for the benefit of the individual under the terms of the trust. So, and private company in which the individual is the director and holds along with relatives more than 2%. This, of course, we can easily understand and agree. And again, similarly, a public company which where the along with his relatives is having 2% shareholding. So, and then if you go to the other side, uh, apart from the ownership, if you see H24AH, a person on whose advice, directions, or instructions the individual is accustomed to act. Again, this is a very broad thing. On the advice or instructions or individual, how to prove this, we have to be careful, and then we have to have something solid as a proof, evidence to say that so and so is a related party. And then if the individual is owner of other companies, any body corporate, a limited liability partnership company, these are all normally we can understand. A company where individual or individual along with his related party owns more than 50% of the share capital of the company. So these are all related parties. Okay. So now there is another explanation given to this section, section 524A, that I'll tell you. This explanation, if you see, for the purposes of this class, a relative, who is a relative of a, or which you have to be treated as a, that is clearly defined. A relative with reference to any person means anyone who is related to another in the following manner. Okay. So now how the following manner is HUF, members of the HUF, suppose brothers are there in the co-partners, what you call as in the HUF, and then the husband and wife, father, mother, son, daughter, daughter's son. So basically for the individual concerned, his generation, his next generation, and the next generation, third generation is also covered as under relatives. Grandson, third grandson's daughter or son, that will be fourth generation. Granddaughter's daughter or son. So, and again, brother, sister is covered, brother's son, daughters. So, what I broadly saying is that, from the individual side, his son, his grandson, and grandson's son is covered up to three generations. And if you go on the upper side, if you see that I'm seeing coming to 15, father's father and mother, that is two generations above the individual. Mother's father and mother, father's brother and sister. So on the other side, sideways also it is covered. So it is any kind of relationship which there is covered. And whenever the relation is that of a son, daughter, sister, or brother, their spouses are also included. So basically, it has become so watertight, the definition of a relative. So now how to see this, we have to see. And then, as I said earlier, apart from the relationship, if you see a person on whose advice, directions, or instructions the individual is accustomed to act. So this is also covered. There may not be a direct relationship, but if there is a what you call some proof that somebody's advice or direction is being taken, then that becomes very significant. So now we have seen this definition, and so basically, broadly, we have to keep in mind that any kind of relationship with the corporate debtor or with the promoter, that becomes a related party. So now how the related parties, now we know it's a very broad definition of related party, how these related parties are treated under IBC. I'll just give you some details. The statutory framework. Section 524, as we discussed, it gives the definition of related parties. And if you go to personal insolvency, Section 79 also defines an associate. There, most of these things are covered. Section 21(2). This stipulates that related parties should not be should not be a member of the COC. So this is the section which bars a related party to be a member of the COC. And then Section 29A, this was inserted later. That's why it is called 29A, not it's part of the regular numbers. This gives disqualifications for submission of a resolution plan. That we'll be discussing more. And then Section 35(1)(f) is there. That is, which says that those not eligible under Section 29A cannot buy properties in public auction in liquidation. So if you're a related party, you cannot think that, okay, if CIRP, I'll skip, and when the liquidation comes, I'll buy the property again. That is also not possible. That is banned. Then if you go to preferential transactions, undervalued transactions, extraordinary transactions, all these where the stipulation is there that in case of a related party, you have to look back for 2 years instead of 1 year. So these are all. I've not covered fraudulent transactions as part of this related. Fraudulent is a general thing. It does not specifically differentiate between related parties and others. But there could be fraudulent transactions connected with related parties. So these are the different sections which, affect the relationship with the treatment of related parties. So now some details about the different sections, let me give you. The same thing, a financial creditor who is a related party of the corporate creditor cannot have representation, participation, and voting in a COC. See, there is another provision which says that the director can be a part of the COC. That is, a member of the board can be part of COC, but a related party cannot be uh, part of the COC. And these people, related parties, they cannot represent, they cannot participate, and they cannot have voting also. Then what is the idea? Why this is done is to prevent insiders from controlling the resolution process. That is the basic purpose. But of course, there is an exception which says that if the related party became related only because of debt to equity conversion or restructuring, they may still participate. This is with respect to banks for whom the debt has been converted into equity, and because of the equity, they become the related parties. So such exceptions are there. This is as far as being a member of the COC. And then next you see disqualification as a resolution applicant. See, apart from the related party status, Section 29A gives many other disqualifications that we will see. Under Section 29A, related parties are ineligible to submit resolution plans, especially if they are promoters or persons in control of the corporate debtor, connected persons of such promoters. Basically, the idea is to prevent backdoor entry of defaulting promoters through proxies. We've seen that, basically, as I said, CIRP, most of the CIRPs involve deep discounts, and they cannot be, promoters cannot be allowed to take advantage of the discounts, which is a natural process of CIRP. Then, as I already said, in respect of transaction through the related parties, we have to see the look back and all that, which I mentioned. Why this is so? IBC assumes higher probability of abuse in related party dealings. It's quite commonly seen in companies also, in terms of giving contracts to related parties, giving, taking loans at a higher rate from a related party. So corporate debtor is subjected to extortionate transactions, corporate undervalued transactions. There could be sale, some property is sold to the um, holding company or the associate company or somebody with a lesser value without, I mean, there could be a valuation report, but valuation report is again from somebody who is close. So when such transactions are there, we have to see if any related party is involved. So there are basically, I said, member of COC and then submission of resolution plan and PUFE transactions. So these are some of the things and how operational creditors are treated. Operational creditors do not have any special bar because of their related parties, but their claims have to be seen closely. Because why their claims have to be seen, whether documentation is there, whether suppose there is a supply of material from a related party, whether proper billing is there, rates are properly fixed, rates are comparable to the market. These are some of the things which we have to see at the time of admitting the claim. Sometimes, we could be seeing that the claim is totally exorbitant. So at that time, we see whether there is proper basis for such thing. We have to see. Maybe we have to accept it, and we don't have the what you call RP do not have the adjudicatory powers, but they have to simply compile and produce. These are some of the decisions in the courts where we have to simply RP does not have, he cannot reject a claim, but then at the same time we have to be cautious, and then we have to uh, we can err on the cautious side, because suppose you are very doubtful, you reject the claim and then you'll go to NCLT and get a clearance. So these are some of the things which RPs can do. And during liquidation proceedings also, the related parties are not barred from submitting claims. They can submit the claims. And in section 53 also, is there, just because somebody is a related party, is there a bar or some disqualification is there? There is no such disqualification under section 53. Section 53, that waterfall mechanism is there, where, depending on workers, is there secured creditors and then governments and then unsecured, and this kind of um, gradation is there, based on which the proceeds are to be distributed. But in that, there is no specific mention of a related party. So basic idea is that there have been some cases where related parties have been discriminated against by the COC, but in some cases it has been accepted. In some cases it has not been accepted. Basically, Supreme Court has held that just because somebody is a related party, they cannot be discriminated in terms of distribution of assets, distribution proceeds. Okay, so and lastly, related parties cannot buy properties under liquidation, which I've already mentioned. So basically, how IBC treats these related parties, the different sections I mentioned, different treatments, how they are given, and all that I just mentioned, so that will be clear what is how the related parties are to be treated and what is the statutory framework for that. Okay, so now before going further, I wanted to mention one case. This case happened before the introduction of Section 29A. This case is why this case is important, I'll tell you. But this case is Edelweiss ARC Limited versus Synergies Jure Automotive Limited. This basically it was handled by NCLT Hyderabad. So I'll just give the background here. In November 2016, if you remember, the IBC came into effect from 1st December 2016. The major sections of CIRP, of course, later sections came at later dates, but then the major sections of CIRP were introduced, were gazetted on 1st December. So in November 2016, 1 month before the passing of CD, this IBC, the CD was going through financial restructuring under BIFR. BIFR Board for Industrial and Financial Reconstruction, which was there. It's an institution which was there before IBC. There used to be a board which used to consider restructuring proposals from banks, and they used to decide on that. So at that time, the debt of Alchemist ARC was 12.56%, and debt of Edelweiss ARC was 8.94%. Remaining debt of 78% was given by Synergies Castings Limited, a related party. So basically, it is not that ARC has directly funded. Some banks have funded and they have sold this particular loan to ARC. Both ARCs are involved, and then they have taken discounted value, and then they became the members of the later. So they were part of the BIFR process also. So in November 2016, SCL assigned their debt to Millennium Finance Limited, and Millennium Finance Limited was not treated as a related party. So a debt which was given by a related party was assigned, and then this debt became a non-related party debt. The IBC came into effect from 1st December, and the CIRP was initiated in this particular case in February 2007. So what happened? When COC was constituted by RP, MFL had a share of 69.32% of the debt and became a member of the COC, though SCL could not. SCL, being a related party, could not become the member of COC in terms of Section 21. But because of assignment to another, whether MFL is a related party or not, that has been discussed, and I don't think anybody has considered that. But apparently, it has not been treated as a related party. So why this has? What is the implication here? Edelweiss ARC, who went to the NCLT and CLAT, who had about 45% vote share in the COC prior to assignment of debt by the related party, lost its vote share to 9.84%. Similar was the status of Alchemist Arts. So if you see this, earlier they were thinking that this SCL is not a related party. So these two, 12% out of 20% they had, and then Alchemist had about maybe 60%, and Edelweiss ARC had about 40%. So they had a good share in the COC. But because of this assignment to Millennium Finance, they lost their voting share. Then why that is important? The SCL submitted a resolution plan even though it is a related party, which was approved by the COC and consequently by the NCLT. NCL submitted a resolution plan because though related party, they could submit a resolution plan simply because they were not disqualified under Section 29A, because Section 29A was not there at that time. So at that time, basically going by the company UK law and UNCITRAL law and all that, only membership in COC was barred, but application, the submission of resolution plan was allowed. So this loophole was taken, and then SCL submitted a resolution plan, and which was approved because Millennium had a huge share. It got approved, and then NCLT could not do anything because COC has approved it, and then they also approved it. And then Edelweiss went to NCLAT saying that this assignment of debt by related party to Millennium Finance is not right and all that. But NCLAT also said apparently the assignment is in order, so there is nothing I can do. Because another thing which was pointed out was even Edelweiss ARC and Alchemist also came into the picture through assignment only, because they were not the direct lenders. So they did not have much voice because of this particular status. So NCLAT upheld the decision of NCLAT. I'm sorry. This is upheld the decision of NCLT. The promoters of the CD could retain control of their company through the resolution plan of a related party. So this particular case, through which the promoter could retain the control of the company in spite of being under IBC. This was discussed like in very much at that point of time, saying that how IBC can be gamed. So this has happened, and then so there is nothing could be done. Then it was discussed, and it became very public opinion was there saying that IBC is getting misused, and then they said some action has to be taken. So what at that time, I think the finance minister, Mr. Arun Jaitley, was there, and um, then he decided that some amendment is required in the IBC to prevent the promoters and related parties taking advantage of the provisions of the IBC. So then they decided to uh, insert Section 29A in IBC. The rationale for insertion of Section 29A. When IBC was first enacted in 2016, it allowed the company's original promoters, which I said, this is this created a significant loophole as it could permit individuals responsible for the company's default to benefit from the very resolution process designed to rescue it. So these are the some of the phrases which were used in the parliament debates also. So basically what we need to understand here is that the corporate debtor is not the same as promoter. Promoters is different from corporate debtor, and once the insolvency process starts, the corporate debtor has to be rescued, and rescue of the corporate debtor could be from the promoter himself. So because it could be that the insolvency basically has arisen in the corporate debtor because of the promoter and because of his actions. So if you allow another party, a related party of the promoter to get in, then he would, what happens is that there'll be a discount to the creditors, and then the promoter will be benefited. He'll all the previous liabilities will get kind of reduced. So he'll be really benefited by allowing the related party. Section 29 was introduced by an amendment in 2017. Earlier, firstly, there was a what you call an ordinance was passed, and there later the amendment was passed. The FM, the finance minister, observed in the parliament that the promoters were attempting to wash off their sins by buying back assets free of past liabilities. The code was never meant to allow a backdoor entry to those who have contributed to the default. So this is a very strong position taken by the finance minister at the time and the government. And then Section 29A was inserted. And if you see Section 29A, apart from the related party status, there are so many other things also which disqualifies people from submitting a resolution plan. So the core philosophy of Section 29A was captured by Supreme Court in Arun Kumar Jatramka versus Jindal Steel and Power Limited. So they considered this section where it was observed that the person who has contributed to the problem cannot be permitted to participate in its resolution. So this is the phrase which used, and similar phrases were used in parliament debates also. The person who has contributed to the problem, that being the promoter or his related parties, they cannot be permitted to participate in the resolution because obviously he is not going to give a proper resolution. This is the bedrock of Section 29A. So this Section 29A, we'll go into the details of Section 29A, but why it was necessary, I discussed one case, Edelweiss and ARC, Edelweiss ARC versus Synergis Dure, where they could benefit because because there was no disqualification in submission of a resolution plan. So this Section 29A inserted certain clauses because of which some people cannot submit a resolution plan. So now I'll go into more details of this Section 29A so that we'll understand how exactly it is preventing the related parties. So if you see the design of Section 29A, the idea is to bar persons responsible for the default of a corporate debtor from regaining control of the company through insolvency resolution process. The principle is default should not be rewarded. Okay, how this is being done, let us see. There is a 4-layered disqualification framework. 4-layered means the applicant, whether applicant, the primary individual or entity submitting the resolution plan, whether he is permitted. Is there any disqualification directly related to applicant? There are some disqualifications to the applicant that I'll go forward and discuss with. And apart from the applicant, connected persons. Connected persons are promoters and those in management and control of the applicant. They are also not permitted. Applicant is not permitted, primary individual and connected persons and related parties. The disqualification extends to related parties of the connected persons, capturing a broader network of individuals and entities. So now, we have seen 3 layers: applicant, connected person, related parties. And then 4th layer is persons acting in concert. Anyone acting jointly or in concert with a disqualified person from any of the above layers is also barred. So how this is important? There is one case we'll be discussing, basically the SR Steel resolution plans. If you see, this becomes very significant. So this multi-layered framework ensures that only the eligible applicant, but also their associates and collaborators are prevented from participating in the resolution process. So the section 20, apart from the definition of the related party, which we have seen discussed, and it is so broad. And apart from that, there are additional disqualifications which will prevent a related party or a interested party in submitting a resolution plan. So there are some more details which I can mention. Section 29A, basically, I've just dissected the thing. And then a person cannot submit a resolution plan if a such person or a connected person is an undischarged insolvent. If a person is an insolvent, you cannot expect him to submit a resolution plan for taking over another corporate debtor. So if such a thing is there, he'll be disqualified. A willful defaulter will be disqualified. Willful defaulter is basically with reference to banks, predominantly. You must have known that most of these banks, they see when suppose a loan goes bad, they'll see whether the default is because of circumstances beyond the control of the promoter, or whether he is actually a willfully defaulting. So they'll identify certain things depending on the circumstances of the case. They identify whether a person is defaulter because they could see there are other transactions are there, other assets are there when the loan is bad. So these kind of things they see, and then they give a tag of willful defaulter. There is a list of willful defaulters maintained by Reserve Bank, and then these banks write to Reserve Bank saying that this company, this person so and so, that so many directors have to be treated as willful defaulters. The list of willful defaulters anybody can see. It is banks especially can see, and then so they have to decide before giving a loan whether a particular company's directors are listed in the willful defaulters list. So if a person is declared as a willful defaulter in any other case, then he is prevented from submitting a resolution plan. So he has to, suppose he says, I'm not a willful defaulter, then he has to go to his banker and convince them, and then he has to get his name removed from the willful defaulters list. Only then he can do that. That is a long-term process. It is not going to be easy. Then third very important thing which has been introduced is Section 29AC. That is, if a person linked to an NPA for more than a year and NPA exists at the time of submission of plan. So it is, suppose a person is submitting a resolution plan, it is not that all his accounts have to be very clear. Obviously, it has to be. And then suppose he is in the past, he has promoted a company and borrowed from another bank and which has become an NPA and it continues to be an NPA. He cannot float another company and come back and file a resolution plan. So, but so they have to see, then we have to see whether particular any what you need to see is in the when a resolution plan comes from a company or for somebody or a promoter of that company, then we have to see whether he is a promoter in any other company, whether that company has any NPS. So we have to see the NPA list. These are all available to banks from RBI. So they have to see whether any account linked to this particular applicant is in NPA. If such a situation is there, then this person cannot be allowed to submit a resolution plan. Then, of course, convicted persons are there. Convicted, suppose somebody is already convicted, imprisonment 2 years for certain offences, and imprison, of course, more than 7 years conviction is there, then he cannot submit a resolution plan. Then, directors disqualified under Companies Act. Because Companies Act also disqualifies people because, suppose they have not submitted balance sheets or they have not done something irregular. Submitted balance sheets, a lot of financial irregularities are there in a company which already is existing. And any person related to such company cannot submit a resolution plan. And similar is the prohibited by a SEBI from accessing securities market. So again, this is a very wide list. And then, so basically, if a resolution applicant is involved in either violations related to Companies Act or SEBI, or he has been convicted under any other particular offense, or he has an NPA account, or is a willful defaulter, all these things are very tightly defined, and then it is excluded. Then apart from what is there, and if you go to 29AG, and then there is another PUFE transactions also. Suppose any company is there where PUFE transactions have been there noticed and some action has been taken. In that case, he will not be allowed to submit a resolution plan for the corporate data. Then this another thing is if a resolution applicant has given a guarantee which is invoked and unpaid to a creditor who is initiated the CIRP for the same. So basically, um, if a particular person is involved in a CIRP in another company where he is liable because of a guarantee, then he cannot submit a resolution plan in the corporate debtors. And then all these disqualifications A to I, which we have discussed, if there are similar disqualifications are there for any particular individual or a company outside India. So India is one, and outside India also any such disqualification is there, then that person is disqualified. Not only that, he has all these disqualifications. That particular person has a connected person with the same disqualifications as above. Includes a person who managed the CD during implementation. This I'll come to this. So what is happening is your connected person also has disqualifications. So then there is a strong connection between you. You cannot submit a resolution plan. This is one step further, saying that if you submit a resolution plan and try to implement the same, and you propose that during the implementation, so and so person will be managing the show, and that person has any disqualifications, which is mentioned in 29A, and then that is also a disqualification for submission of a resolution plan. So all these things are very broadly defined and then very specifically mentioned for disqualification. So section 29A thus is one of the most extensive section which covers the disqualifications. But MSMEs are exempted not from 29A, but two classes of 29A. Two classes are section C and section H. Section C is relating to what we have seen is relating to person linked to an NPA. Suppose he has an NPA account, he is an MSME and he has an NPA account somewhere else, but he can submit a resolution plan. And similarly, H is meaning that he has given a guarantee and that guarantee has been invoked in another CIRP. But in spite of that, he can submit a resolution plan because he is an MSME. So these are the things which. So there are so many aspects which have been covered in Section 29A. Obviously, you would expect that they will be challenged in a court of law. A lot of sections were challenged, and then many appeals went to Supreme Court, and Supreme Court in one particular case, which is called Swiss ribbons. Most people would be aware of Swiss ribbons, and in that particular section, case, Supreme Court basically dissected the sections, various sections of IBC, and then approved and confirmed whether they are valid. So, what Swiss ribbon? I'll just mention what are the things. Especially, a lot of things have been covered in Swiss ribbon case, but specifically with reference to Section 29A, I'm mentioning here. One of the objections has been that efficient but defaulting managers are clubbed with unscrupulous promoters. There is a blanket ban on submission of resolution plan if there is a default. But deficient, basically there are situations where because of external factors, some company becomes a defaulting company. There could be some change of technology or change of policy of the government. These are things which are beyond the control of the promoter. But even in such cases, the promoter is disqualified. So this is one of the major items in which the Section 29A was questioned in the Supreme. So what they say is these such people may bring the best resolution plan. This right is denied to them by Section 29A. So if there is an unscrupulous promoter is there, maybe it is understandable. But suppose the promoter's default is on account of external factors, then he should not be penalized. It is completely irrational to prohibit former promoters' family members. And this is another item which has been mentioned in the Supreme Court appeals. How you can prohibit former promoters' family members from participating in the company under Section 29AJ, even if they had no real involvement in the running of the company. So now Parliament said, the Supreme Court said, Parliament introduced section with a specific purpose, and that is to ensure persons responsible for the insolvency of the CD will not get the same enterprise at a discounted value at the cost of the creditors. A resolution applicant does not have a vested or this is another aspect which has been mentioned by Supreme Court. A resolution applicant does not have a vested or existing right to demand that he be considered as a resolution applicant. So there is nothing. People have said that my basic rights, Article 14, has been violated and all that. But Supreme Court did not agree with such an interpretation. They said no. You do not have any particular right to saying that to demand that I'll submit a resolution plan and this is my personal right or something like that. There is nothing like that. So basically, the SC examined the various aspects of Section 29A and upheld the provisions of the section. So almost all the items were cleared by the Supreme Court. So Section 29 has remained, and then it continues to be one of the major walls to prevent misuse of IBC. This is as far as Section 29A is concerned. So now there are certain cases which I said I'll discuss, but before going there, I want to discuss what is the role of RP as far as Section 29A is concerned and as far as related parties is concerned. The resolution professional has a pivotal duty to enforce Section 29A. They must conduct comprehensive due diligence on every prospective resolution applicant to verify their eligibility. An affidavit from the applicant is not sufficient. The RP is required to provide a detailed due diligence report to the committee of creditors, which must consider this report when evaluating or approving any resolution plan. So basically, the idea is that the RP has a very big role in approving a resolution plan, because he has to, that is, the threshold of RP has to be cleared before COC can consider the resolution plan. But and a lot of efforts are taken by RPs to see that a resolution plan is not disqualified by Section 29A. In fact, there are agencies which are doing this particular activity, which take up a case and a resolution plan and see how whether any particular disqualification applies to the resolution plan. So basically, we need to see a resolution plan: who is the applicant, who is the promoter of the company, and whether what is his relationship with others. And it is very difficult task, because the names could be similar, and people like people like Agarwal or Gupta, they are very common names. So such names are involved. It is very almost impossible to find out whether any related person is there in any particular company. But this is, to the extent possible, we have to do this, and then we have to do a lot of data we need to collect, and then we have to ask the resolution applicant to satisfy yourself. So this is the role of RP, because this is not something which can be what I call delegated, or you can ask COC members to give their view. We have to decide, and once you decide, we have to be very clear about the disqualification, whether disqualification is valid or not valid. You have to satisfy the courts also. NCLT, somebody will go to NCLT and say my disqualification is not correct, and then you have to satisfy NCLT in flat and all that. So this role of RP in Section 29A is paramount. Then now I was telling that there are some cases which try to give you more meaningful interpretation of this related party concept. So I'll discuss some of the cases. There are about 5, 7, 8, 10 cases. Before I start the cases, Madam, we want to take a break or something, or we can continue?
We can
Sir,
continue.
if you want, you can take break.
We can take a break.
Sure, sir.
So it's 11:15 is there. Maybe we can take a 10 minutes break and come back up around 11:25 or so.
Okay,
Okay,
that's
sir.
okay.
Okay, thank you. బాగానే పోతుంది ఇంతవరకు. ఇంకో 10 కేసులు డిస్కస్ చేయాలా, ఇది అవుతుంది. ఇంకొక గంట సేపు లాగిస్తే 11:30 మొదలుపెట్టి 12:30 దాకా 10 కేసులు డిస్కస్ చేస్తే మళ్ళీ ప్లేస్ అవుతుంది. తర్వాత ఒక ఎక్స్టెండ్ 12:45 1 o'clock క్లోజ్ చేయాలి. 12:45 క్లోజ్ చేసి ఏమైనా క్వశ్చన్ ఉంటుంది. ఎవరు
చెప్పుకున్నాను పోస్ట్ కార్డు ఇప్పట్లో ఎక్కడ పెట్టినారు
Yes, friends. Now, basically, as I said, we have discussed in detail. Am I audible?
Yes, sir. Audible.
Yes, sir. Audible, audible.
Audible, sir.
Am I audible?
Yes, sir. Yes, sir. Wow. What happened, sir?
You can start.
Can I go ahead?
Yes, sir. Yes, sir.
Okay. So I was mentioning the detailed clauses about the definition of related parties and the many clauses which disqualify a resolution applicant to submit a resolution plan. Now, some of the landmark cases I'll mention to you. There are many cases, but then some of the things which I thought maybe it will be relevant, I've selected. This case is about Phoenix ARC Private Limited versus Spade Financial Services Private Limited. The Supreme Court decision. At what point of time a related party gets disqualified to be a member of the COC? Because in this case, see, there are several cases where there is a related party, but before start of COC or something like that, they come out of this status of related party by maybe assignment of a particular loan, or they'll resign from other company, and they'll try to submit a resolution plan saying that I have no connection with this corporate debtor and things like that. So basically, the section 21(2) states that a committee of creditors shall comprise all financial creditors of the debtor shall not have any right of representation. That we have discussed. In this particular case, what had happened is a particular resolution applicant was there. He claimed that he is no longer a related party. So the question that came up is whether at what stage you see whether a related party it continues to be a related party or not. Whether suppose there is a loan maybe given to the corporate debtor maybe 2 years back or 1 year back, and that loan has been closed. And at this stage, whether they had to be continue to be treated as a what do you call related party or not. So in this case, Supreme Court clarified that the above exclusion of a particular person applies to financial creditors who are related parties in presenti. In presenti, that is at the time of CIRP, because when the maybe you could take initiation of the CIRP or at the time of the submission of the resolution plan. So you can say if at present they are related parties, then they have to be treated as a related parties. But suppose what about the past association? But that we need to see again the circumstances of the case. If a financial creditor was a related party at the time of debt, if the financial creditor was a related party at the time the debt was created, but ceases to be so merely to circumvent exclusion from the COC, such creditor should be treated as a related party and excluded. So now, so again, it depends on situations in a particular case. Suppose you find that in this case, what had happened is, if you see the last line, the loans of the FC were unsecured, transactions lacked commercial substance, interest was not paid, and security was not registered. So their loan was created on paper, but then it did not have any other characteristics of a loan because interest was not paid, and then no security was there, and then no proper agreement was. So all these things were there, which clearly show that the money was given, but then it is not as a loan transaction. So only thing is subsequently they say no, this is not a loan. I'm not a related party. So what Supreme Court says that if you have to see the nature of the transaction. Basically, the idea is that you have to see the relationship and not the present debt. Debt, of course, is there or debt is not there at the point of time is another matter. But there is a relationship. If it is there, the relationship has to be considered. And if there is a solid relationship is there, then you have to treat the particular party as a related party. This is the crux of the this agreement, this particular Phoenix ARC Private Limited versus Spade Financial Transactions. So now this is quoted as far as related parties is concerned. This is quoted as a very significant case because Supreme Court has held that you have to see the substance. It is not just the form. You have to see whether the relationship is there, maybe prior, maybe sometime prior to CIRP, or how the relationship is there, depending on if somebody is able to prove that a relationship existed and related party status is there, then you have to treat the particular person as a related party. Okay, now let us move to the next case. This is referring to an NCLAT decision in the case of Hari Vittal Mission versus Ravi Sethia and others. This is basically in this case, a trust is involved. What happens is that Hari Vittal Mission is the trust which has given a loan to the corporate debtor. Corporate debtor was to construct a hospital, and then some decisions, some particular number of beds were reserved for this particular trust, so they can give it to the people, whoever the beneficiary. This loan went bad, and then Hari Vittal Mission is treated as a financial creditor. It's a loan structure only, but there is no difficult. But the point here is that this particular trust, Hari Vittal Mission, and the corporate debtor, the hospital, it's a hospital. I've not mentioned the name here, but the hospital. So they were part of another foundation called Canoria Foundation. So there is no direct shareholding. Even without direct shareholding, substantial influence exercised by a common entity, in this case, Canaria Foundation, over both the creditor and the corporate debtor is sufficient to establish a related party relationship. So this is a case where if you see, this is a case where the exercise of influence. If you see the definition, one second, let me go back to the definition here. If you see the definition, even if there is no direct shareholding, we were talking about any person associated with CD or by participating in the policy making, any person who can control the composition of the board, any holding company. In this case, these are all the things which are, there is no direct shareholding or direct relationship, direct sharing of directors or anything like that. So, but because of this influence is there, they were treated as a related party. So this is also a significant phase, says where irrespective of the structure, how exactly the relationship is there. On paper, suppose there may not be any relationship, but the substance is seen, whether there is any influence is seen. If there is a substantial influence exercised by a common entity, then it is a related party. So the idea is that, as I said, it's a substance over form. The judgment reinforced the principle of looking through complex multi-tier shareholding structures to the underlying reality of common control, rather than relying solely on the formal legal nature of intermediate entities. The existence of a trust in the ownership chain did not break the chain of control in this case. So this is what because that it touched the trust part of the definition. I thought I can just discuss this case also with you people. Then let's go to next case. Disqualification arising out of an NPA account. We are familiar with this. The concept is that, as I told you in 29 section 29AC, suppose there is an NPA account for which the resolution applicant could be traced to be responsible. He is a promoter of a company which has an NPA account, or any such relationship is there. This case is um, COC of SR Steel India Limited versus Satish Kumar Gupta, 2019 case. In the CIARP of SR Steel, the resolution plan submitted by ArcelorMittal Steel was rejected by the RP, as they were promoters of two companies, Mrs. Uttam Steel and Mrs. KSS Petron, whose accounts were NPAs with banks. This Uttam Patel and KSS Petron were NPA accounts. Of course, ArcelorMittal was not directly running these companies, but then they had promoted and they were shown as a promoter of these companies. When they submitted a resolution plan, this came up into question, and then RP said, since you are a promoter in those two NPA accounts, you are not eligible to submit a resolution plan. Then the matter went to court, so it went to NCLAT, NCLT, NCLAT, and Supreme Court, and all that. In the meanwhile, what the resolution applicant tried to do is, this ArcelorMittal, what they have tried to do is, they sold the shareholding in these two companies, and then they tried to declare to stock exchange and to ROC and all that. They are no longer the promoters of the company. So they should be treated as non-promoters. But somehow that did not happen, because maybe the reporting was taking time, or the process was taking time on it. So it was not happening. But this particular effort also uh, did not prevent the disqualification. But the Supreme Court also upheld the decision of the RP, that it agreed that if there's an NPA account, he is a related party. That part was agreed upon. But the second part was there, saying that if there is a NPA account, the resolution applicant has to be given some time, about 30 days or so, that has to be given there. And then if he is able to pay off that NPA account, and then he becomes eligible to submit a resolution. In this particular case, ArcelorMittal paid off those loans, or they had somehow they managed that loans were closed, and then their resolution plan was accepted. So this is the case of ArcelorMittal. Ultimately, they took over the SR Steel also, but this is very important in the that NPA account is there, it will be a disqualification. Next case also relates to SR Steel, where the resolution plan submitted by the other party, because ArcelorMittal was one, and another party was called New Metal. New Metal is a consortium. So this plan was rejected by the RP, stating that RA is a consortium of four companies, one of which is promoted by Mr. Revant Ruya, a son of the main promoter of the CD. So on the face of it, New Metal is a consortium, and then directly there is no relationship. But because of uh, indirect relationship, because indirect company was promoted by Revant Ruya, it was held that it's a related party, and then the resolution plan was rejected. In this case also, Supreme Court upheld the decision, observing that the opening lines of Section 29A refer to a de facto position as opposed to a de jure position. That is what actually situation on the ground will be seen, and not just what is happening on the paper. This particular clause, what the Supreme Court says is this particular clause 29A is a typical instance of see-through provision, so that one is able to arrive at persons who are actually in control, whether they jointly or in concert with other persons. It is important to discover in such cases those who have set up a corporate vehicle for the purpose of submission of a resolution plan. So in this case, if you see this new metal, the company, this was just registered maybe a few days back, a few days before the submission of the resolution plan, which means that the conclusion was that this particular new metal was set up only for submission of resolution plan to SR Steel. So when they saw this development, then they said, then who is the people who are promoting it, and who are the other people? All these details were collected, and it was found that the promoter's son, SR Steel's promoter, Mr. Ruya, his son is also involved in this new matter. So they said it is not a fit case for submission of a resolution plan. So basic idea is relating party. The learning is that relating party acting in concert. So even if there is no direct relationship, this has to be seen. This is a case which so acting in concert is another matter which has to be examined. Then another case where is interchange of managerial personnel. You see, I've shown that there is a law, there is a case here. If you see beyond ownership and control advice also, so suppose there is a collaboration, and this particular clause, if you see 524M3, any person who is associated with CD on account of interchange of managerial personnel between CD and such person. So it's a suppose there is a big group and people of exchange, managers such get transferred from one company to another. So whether that is a case for interchange. So this aspect was examined in this case of Bank of India versus Mr. Naren Seth of Jai Bharat Textiles and Real Estate. So in this case, what I meant just is that a person who is associated with CD on account of interchange of personnel becomes a related party. But NCLT Ahmedabad has held that interchange of managerial personnel between various legal entities inter se without any association with the corporate debtor will not make them related parties. So in this case, it is not denied that there is interchange of managerial personnel, but court took the view that just because there is a interchange, it doesn't become a case for related party. It was held that provisions relating to exclusion of related parties from COC is to maintain the independence of COC in the interest of all stakeholders. But that does not mean that parties who are related at some point of time and now they are not related parties should be excluded from COC. So in the past, there could be a relationship. But suppose there is no, because in the earlier case, in Phoenix case, I said that the Supreme Court says that the relationship has to be there in presente. That is, at present, there has to be a relationship. If there is no relationship at present, and there is a relationship, there was a relationship in the past, we need to see whether the relationship ended for what reason. So we need to see what is quoted. I have highlighted here. Unless it is shown they extinguished their related party status just to dominate CIRP to gain undue advantages of CIRP. So suppose something, some loan is closed in the normal course, or interchange happened, but in this case it was held that interchange of directors has no relationship with the corporate debtor. Such cases are exempted. I mean, you see, basically the idea is that you simply cannot have a blanket application. So that is the idea is here. What NCLT said, the text and context should be matched with the object of IBC 2016. And if on that basis it is established in a given case, then the parties on the basis of past relations can be treated as a related party. Only they have to. So the idea is that deeper examination is required, and again I return to the same concept, that is substance has to be seen over the form. So this is another case which says that though there is an interchange of personnel as defined in the 524, but here it was not allowed. It was not accepted as a basis for related party status. Then there's another case of SRI, Shrai Infrastructure Finance Limited versus Canara Bank. This is the case where corporate debtor is DHFL, Diwan Housing. So in this case, what had happened was SRI Infrastructure, SRI, a financial creditor of DHL, was declared as a related party by the RP based on the shareholding of the FC being more than 20% in DHFL. RP did not allow the FC to be a member of the COC, and NCLT confirmed the same. So DHFL, 20% of the shareholding of DHFL, the corporate debtor, was with Shrai Infrastructure. So straight away, RP said, you are a related party and you cannot be a member of the COC. But you have to go further into the transaction. SRA claimed that their loan given for the time value of money was converted to shareholding by the CD, and as such, they continue to be a financial creditor rather than a shareholder. So what they say is that we have given a loan only. I am not a shareholder by buying the shares. The conversion has happened, and then that too conversion has happened. DHFL, not because SRA was interested or they asked for it. The DHFL simply said, I'm not able to pay the loan, so I convert your loan into equity. So then NCLAT looked into records and found that the allocation allocation of shares was not approved. Was not approved by the stock exchanges due to non-compliance of guidelines. So what had happened was they found that RP says that you are a shareholder, but then it was mentioned in the balance sheet as a shareholder, but there is a note in the balance sheet. Balance sheet note says that um, this particular thing was not accepted by the stock exchanges. So what had happened? Though the shareholding was allocated and all that, the actual status of a shareholder was not given to SREI in the books of ROC and in the stocks exchanges and all that. They said allocation of shares was not approved by the stock exchanges due to non-compliance of certain guidelines. So when this was seen by NCLAT, this was not seen by RP and this was not seen by NCLT. In the balance sheet, there was a note. That particular note was not seen by NCLT or RP. But then NCLAT observed that this note is there, due to which the shareholding has not been given. So NCLAT declared accordingly that SRA is not a related party and directed their inclusion in COC. So this is another case, though on the paper there is 20% shareholding, but when you go into the details, you find that it is not there. This is another instance of substance being given more weightage than the form. So 2-3 cases are mentioned like this. And then there's one more case we can see. In this particular case, Punjabi Accessories Private Limited versus Credo Beauty Private Limited. This is an NCLT case where there were no creditors and some loans, somehow four people were there, four shareholders. They became the members of the COC. So RP submitted the same to NCLT, comprising entirely, and they approved a resolution plan also, and then it was submitted to NCLT. NCLT found from the records that the two shareholders, who were also the members of the COC, were involved in passing a resolution to remove a director. So when the previous, they were going through the record, there was a resolution in which a particular person was appointed as director. And then this approval was given by the shareholders. And shareholders, one of these people, the two people out of these, see, actually the basic background I would mention, the two shareholders here, they had 19% shareholding, 19% each. So they try to avoid the related party status by not taking 20% stake. So 19% stake they had taken. But then, so based on that, whether, so they are not related parties. But the NCLT looked into the matter and they said, the bench held that COC members were capable of controlling the composition of the board of directors. By virtue of the same, it concluded that both the COC members and COC as a whole comprised of related parties. So what they say is, if you can appoint a director or you can pass a resolution and you are involved in passing of the resolution in appointment of a director, then you have a say. You have a what they call here it is mentioned as, by virtue they control the composition of the board of directors. They were capable of controlling. So this conclusion was reached by NCLT. And then since they have this capability to control the composition of the board, they have to be treated as a related party. So in this case, they said since related parties are comprising the COC, the plan approved by the COC is void, ab initio. So the plan was rejected. So lot of deep study is being taken up while you're deciding this also. So another related matter is Arun Kumar Jagat Ramka versus Jindal Steel's Power. In this case, what had happened? Gujarat NRE Coke Limited is the CDI. In this case, went into liquidation. So there was no resolution plan, and or probably resolution plan was not accepted. This person, the promoter, has submitted a resolution plan, but it was not accepted because he's a related party. So then the company went into liquidation. The resolution plan submitted was not approved as he was not eligible. This was challenged in NCLAT, and NCLAT also said liquidation has to go through. And then the matter went to Supreme Court also. But while the matter was in NCLAT, Mr. Jagat Ramka, the promoter, moved an application under Section 230 to 232 of Companies Act before the NCLT Kolkata for compromise and arrangement between the erstwhile promoters and the creditors. So this section 230 to 230, you can file for compromise under Companies Act. So he has done that, and since it has nothing to do with IBC, the court separately permitted this compromise arrangement. However, when the matter was known to the Supreme Court said the prohibition placed by the Parliament in Section 29A and Section 35(1)(f) of the IBC must also attach itself to the scheme of compromise or arrangement under Section 230 of the Companies Act. When the company is undergoing liquidation under auspices of the IBC. So basically, this loophole, this gap was there, whether a party disqualified under Section 29A in ABC can submit a compromise plan under Companies Act and get it done. But Supreme Court clearly ruled saying that such a loophole does not exist. If you are disqualified under Section 29A for submission of a resolution plan, then you are also disqualified for any such compromise arrangement under Section 230 of Companies Act. So this is another clarity which was given. Any questions so far? Okay. Now, next case is Rare ARC, Rare Asset Reconstruction Company Limited versus VR2 Land Development Company. In this, there is an assignment in this case, but assignment was questioned, but then it was accepted. The details I'm just reading out. The IIFL Finance, an FC, was held to be a related party of the CD by NCLT because of certain transactions with the company who was funded to take over the corporate data. In this case, basically what had happened, the corporate debtor's loan was in default. What IAFL tried was it tried to fund another company and said, you take over this corporate debtor and run it. So with the loan I'm giving you. So the takeover was to happen, and there were somehow it came to notice, and then the other creditors objected, saying that this company is trying to take over corporate debtor. He is also funded by, and so that becomes a related party. So it was accepted, and the resolution plan approved by the COC was also not approved in the NCLT. Later, IAFL assigned the loan to RSIL, and who further assigned it to Rare ARC. So the question is, if IAFL is a related party, they said, okay, I'm a related party. In that case, they assigned the loan to RSIL and then to Rare ARC. And then these two, Rare ARC said that I have to be a member of the COC. Then the matter went to the NCLAT. NCLAT noted that the issue of IAFL being a related party is of not much relevance now when the matter came, as both the entities to whom debt is assigned are independent entities and are not related to corporate debtor. So again, that in present matter was seen, and then they say that at present the assignee is Rare ARC, who is an independent entity and has no relationship with corporate debtor. And so the question of treating Rare ARC as a related party does not come. In the earlier case, IAFL was a related party, but whether that relationship gets extended to another assignee is a far-fetched thing. That's what NCLAT said. It doesn't automatically follow like that. NCLAT quoted the Honorable Supreme Court in Phoenix case, wherein it was held that disability under Section 24 pertains to related party and not to the debt. That is, relationship party has to be related party. The debt could be assigned, and any assignment of the debt in good faith to an unrelated independent third party should not disqualify the assignee, transferee from participating or voting in the COC. So this is, you will see that the pendulum swings this way or that way in the courts. Sometimes they say this is acceptable, sometimes it is not acceptable. Suppose there is an influence. In the case of the trust, Hari Vital Mission, if they said just because there is an influence of the common promoter, they said it is a related party. In this case, it comes to that, NCA, the loan has been paid off, it has been assigned. So the earlier disqualification does not carry through. So it all depends on how exactly the particular relationship is seen. And this is another matter saying that now So far, we have discussed about the submission of relationship, resolution plans, and being a member of the COC, all these cases. And then this is another case where the question whether a related party has to get a lesser amount when the resolution plan is finalized, because distribution takes place, and then distribution can be like different creditors, secured creditors get unsecured creditors, and financial institutions, all these financial statutory departments, all these people get some share. So at this particular point of waterfall being decided, whether the related parties should be receiving any lesser amount because they are related party. So some people have argued in the COCs saying that no, it's a related party. We need not give the full share or whatever applicable to a unsecured creditor. We cannot give. But here in this case, the Honorable Supreme Court clarified that while related parties cannot participate in the COC, which is clear, and they cannot be resolution applicant, they cannot submit a resolution plan. But at the stage of distribution of the proceeds, they cannot be discriminated against the resolution plan, in the resolution plan by denying them payments solely on the ground that of being related parties. So if you're a related party, maybe you will not be a member of the COC, you cannot submit a resolution plan, but that does not mean that a related party cannot get back his money. When everybody else is getting, he'll also get on the same lines, irrespective of the fact that he's a related party. The court held that a rational nexus must exist for any classification. Held that a rational nexus must exist for any classification, and a related party financial or operational creditors have the right to receive payments under the resolution plan. So this was also clarified, saying that the status of related party, because Section 21 says that you cannot be a member of the COC, they are prevented. Section 29A says that you cannot submit a resolution plan, so they are disqualified. But the status of related party was up to that point only. There is no specific clause or specific provision in the IBC saying that because you are a related party, you should get lesser amount. There is nothing like that. That is what Supreme Court said. And so payments to related parties under resolution plan do not sabotage the CIRP. That is also noted. Suppose there is a CIRP and ultimately this related party is getting the amount. It is not because some influence of the related party is there on the matter. Because the COC without the related parties has decided that this is the distribution mechanism, and then in that a related party gets a higher amount and he gets it because he is not going to suffer because he is a related party. This is the conclusion. But there's another case which is decided on the other side. This is West Coast Paper Mills Limited versus Vijay Murmuria RP and others by NCLAT. The earlier decision was also by Supreme Court, but this is NCLAT decision. Maybe they have found a different approach. In this matter, NCLAT held that there is no provision in the IBC mandating that related parties must be paid on par with unrelated parties. See, earlier case we said that they cannot suffer because of their related party and they cannot get lesser amount. In this case, the matter says that they can also not get a higher amount than related parties. Then CLAT upheld the commercial wisdom of the COC in deciding whether to provide for payment of related parties in the resolution plan. If COC says that I'll not give a higher amount just because a related party is a related party, that is acceptable. Because the concept of related party does not affect as far as distribution of waterfall distribution proceeds the CIRP procedure is concerned. The NCLAT observed that differential treatment of related parties in the resolution plan is permissible and does not contravene statutory provisions. So earlier, the Supreme Court said, no, you cannot do that. But in this case, I don't know. NCLAT said it can be done. Then the other side, the bench rejected the argument that non-payment to related parties violates the code. So they said if suppose the related parties do not get any amount at all, it's okay because there is some strong reason for that, and commercial wisdom is there based on which it is decided that they will not get anything. So if such is the case, then there is no problem. It is acceptable. So what I find is that sometimes the pendulum goes this way, sometimes it goes that way. But you have to go into the details of the case to understand where exactly the difference is happening. So these are some of the cases, I thought which might be of interest. So now, let us basically try to summarize what the court's attitudes have been, how the courts have been interpreting this particular relationship, related parties concept. So learning points from the case law. The related party status under IB is determined based on the present relationships and control and influence over the corporate debtor, not merely past associations. We have seen that especially in the case of interchange of personnel, sometimes back it had happened that need not affect whether in the present situation, whether that is there is what to be seen. So in presently, that concept is very material. Second thing is the related parties are excluded from the COC to prevent conflicts of interest. Any attempt to circumvent this exclusion by any means will be closely scrutinized. So I was mentioning they're saying that just before the COC's formation or just before the submission of the claim, a particular party comes out and says that the loan is repaid or something else happens, and then there's related party status they want to scuttle. But court says that if such a deliberate attempt is seen, then it will not be accepted. Third thing is, even in the case of complex structures, the control or influence on the corporate debtor will be examined, giving importance to substance over form. This control or influence, how control or influence, there was somebody was also asking how to prove that control or influence is there. Then basically, some evidence is seen or some circumstances clearly indicate that so and so party is influencing or controlling the corporate debtor, the performance of the corporate debtor, or the decisions. If such a case is there, then it becomes very material, not because there is a particular shareholding is not there or anything like that. The RP has the authority to decide related party status. Again, this has been clearly mentioned in Phoenix case by Supreme Court. Who decides whether a particular party is a related party or not? It is the RP who decides that. And I've not come across many cases where RP's decision has been questioned. Sometimes it goes, but then most of the times RP's decision is held. Okay, so now there are some more points also. The relationship of the related party must be with reference to the corporate debtor itself. That is, see, just because in the case when you're dealing with a CIRP, we have to see taking the corporate debtor as the central point. For the corporate debtor, whether somebody is related, that we need to see. Suppose some associate company or holding company is there, if there is no direct relationship is not established with the corporate debtor, then we cannot be. So the example is given here. If X is a related party of Y, and then Y is a related party of X, then they both become related parties. But if A is related to B and B is related to C, okay, A is not automatically related to C. So the point is that C is not directly related to A because it is an indirect relationship through B. In such a relationship is there, it is not accepted as a related party. The relationship has to be specifically covered by a subclass in section 524 of IBC. So when you have a doubt whether somebody is a related party or not, we have to see under which particular clause of section 5 this relationship has to be fitted. Suppose you are not able to fit anywhere, then it's not a related party. But of course, there is a very broad clauses like having influence or working in concert or something. In spite of such clauses, also you are not able to say that a particular clause is the clause in which a particular person becomes a related party. In that case, the related party status should not be given. He will not become a related party. Then the other side of it, NCLAT has held that control under Section 524 includes not just direct shareholding, but also substantial influence over management decisions through voting agreements, clauses in trust deeds, and historical actions. So this is what again a repetition of what Wayne saying that control has how control is exercised is something which we have to see closely and then decide. The core principle is that genuine independent creditors should drive the CIRP, not those connected to the corporate debtors, management, or promoters. So this is the basic idea that independence of the COC, that influence of corporate debtor, influence of the promoters of the corporate debtor should not be there, and how to ensure that is the job of the RP. If there is any doubt about somebody being related or some relation is there, then we have to call it out and say that he is not eligible to be a member of the COC. This is the basic idea. So now any other point which requires some application, any other thing which people would like to raise at this point, or your experiences you want to share, or any particular case where this has been interpreted. If you have any such experience, you may quote at this stage before we go into the next section. Now, next, what I've done is we have discussed the broad definitions and broad interpretation of the definitions and how these things. And then I've given you almost about 10 cases where the different aspects of the definition has been interpreted. So basically, I think the concept of related parties is basically clear and how it is to be seen, how it is to be interpreted in our daily working in CIRPs. I think basically we have discussed that. Now I have a simple case I have discussed just to apply what we are doing, but it's a very simple matter. But let us go through this case. This is a case of ABC Infra, who is the corporate debtor, who has defaulted for 500 crores. Bank X is the financial creditor, unrelated definitely, and then 200, they have 300 crores. And then finance company Y is an NBFC who has funded the corporate debtor, but this NBFC is controlled by promoter's brother. So obviously a related party. But of course, there is a loan agreement between the two parties and the interest rate charge is 24%. So it's a proper documentation is there and loan has been given by the NBFC. The promoter of the company is Mr. P, who is holding about 60% shares. And there's a operational creditor who has submitted a claim, supplier Z. So this entity is also controlled by the promoter, but they have been supplying materials. So it's an operational creditor who has submitted a claim for 50 crores. And this corporate debtor, ABC Infra, is a subsidiary. It's a holding company is there. Holding company is a hedge. This holding company is a very strong company, and they have this subsidiary, but it somehow subsidiary has gone into CIRP. Then there is an investor called unrelated third-party investor called M, who wants to submit a related resolution plan. There's another information which is given is that 18 months before ICD, insolvency commencement date, ABC sold a land parcel worth rupees 100 crores to H being the holding company, for rupees 40 crores. So 100 crore property has been sold at 40 crores. So CIRP has initiated. Now, with this background, there are some questions which we need to see. And then I'll be happy if people can respond. So let us see what are the questions. Some issues are there. You are able to see this?
Yes.
Yeah. Issue 1. Can finance company Y be a financial creditor in COC? If I want, what I can do is let me see if I can give the basic details in the chat box. I don't know whether that will work out. Let me see. Yeah. So basic background facts are given in the chat box here. Okay. So now you can see the chat box and the background information is there and the questions we'll discuss. First question I asked is, can finance company Y be a member of the COC? Anybody? Or you can put your reply in the chat box also. One answer is no. Because we said the NBFC is controlled by promoter's brother. Promoter brother becomes a relative of promoter, and then so there is a direct relationship, and then so we treat him as a uh, related party. So he'll be out of COC. Very easy. Can promoter P influence the resolution process? Can he attend the COC meetings? Promoter we said is 60%. We also take that he is a director in the company. So whether he can attend the COC meeting?
The promoter P is a related party. So a person in control of the corporate debtor and have no statutory right to attend COC meetings.
Correct. See, if you see from the angle of section 21, he is a related party and he cannot attend. But if you go to section 24, 24 says that when sending a notice, RP has to send a notice to the members of the board. See, I'll read that 24 subsection 3. The resolution professional shall give notice to each meeting of the committee of creditors to A is members of the COC and authorized representatives, and B is members of the suspended board of directors of the partners of the corporate persons, as the case may be. Then third is for operational creditors having more than aggregate dues of not less than 10%. So promoter is a member of the board, and
Certainly,
in
is a
that
member of the
capacity,
board.
he
His
has to be
attendance
invited.
is only symbolic. What I'm saying is, his attendance is only symbolic because he cannot participate.
Very true, very true. I mean, he cannot he can attend as even as a board member. He is called, but he cannot vote. That is very clear. He cannot vote, and he cannot also participate in the way. But um, if some information is required about the corporate data, suppose what had happened this year, that year, or something like that, and some development which has not been aware, which is RP is not aware. In such cases, the director can be asked to explain, and it is his duty to cooperate and tell. So, as far as giving the information to the COC, as far as providing data and providing balance sheets and all that, there is a duty and he has to meet that. But definitely he cannot participate, or participate in the sense that participate in the decision making of the COC. He cannot vote. So that is the distinction. Oh, so what you say is right, but then in the sense that officially you'll be invited for the COC meeting as a board member.
Of course.
Next issue is, can the holding company H submit a resolution plan?
No, it's a related
I said
party.
resolution plan. Holding company is a very strong company, and then they would like to retain the uh, ABC infra in their fold. So where they can submit a resolution plan.
No, they can't. It's a related party under 524. It's a connected
Very
person
rightly.
voter.
Very right. As a holding company, it is a related party, and then they are not allowed to submit a resolution plan. In terms of Section 29A, they are disqualified. Fourth issue, can supplier Z submit a claim? Supplier Z, we said, if you see in the background, is a related party, operational creditor. So he's not basically an independent person, but the question is whether a claim can be submitted by him.
Of course, he can submit the claim. Submission of
Yeah,
claim is not barred,
correct.
but he will not
But
be part of COC.
yeah, he will not be part of the COC. As an operational creditor, also, he will not be part of the COC in any case, unless his claim is more than 10% of the total claim. That clause is there. But he will not be part of the COC. But you cannot deny that he can submit a claim. And then following that, suppose the operational creditors are getting some amount in the resolution plan, which is approved, then he should be given that. Supplier will get that amount, irrespective of whether he is a related party or not. That
There
also
is
has
no
been
bar
made
under
clear.
Section 53.
Yeah, under Section 53, correct.
Yeah.
So supplier Z can submit a claim. That is yes. Next issue is there any action required on the transaction of the sale of land? We said there is a sale of land, 100 crores worth sale land has been sold by ABC Infra to holding company H. So whether that requires any action?
It's a clear case of undervalued transaction.
Correct. It's an undervalued transaction, and then he is also related party. So definitely RP has to submit a application for reversal of the transaction. Next case is the next question. Is there any other transaction which can be covered under PUFE transactions? Any other transaction, if you see the background, if you can identify any other transaction which can be treated as
That
an
is
authorized transaction.
promoter controlled and NBFC. Interest is 24%, too high.
Exactly. 24% can be treated as an extortionate transaction because because when related party is giving a loan and then corporate debtor is taking the loan as a related party, charging 24% is definitely uh, not right. It is unusual, and basically the idea is that you take away money from the corporate debtor. That is the basic idea of the transaction. So that can be if RP can make an application saying that this particular extortionate transaction has to be treated as an extortionate transaction and has to be reversed. That is possible. He can do that.
And it might invite action under 66 also.
Yes, as a fraudulent transaction. Yes, it can be done.
Sir, how he can take the money?
No, he is charging 24%, means corporate debtor is paying 24% for the loan, which is given by the related party, which is a high rate of interest. In the norm, suppose he goes to a bank and he can borrow maybe at 12%, but he is paying 24% and taking a loan from a related party. So that 12% extra is taken away from the corporate debtor. That is the idea.
And Z is also there, which is a promoter controlled OC.
Correct. That is also there. That's why I said, no, when operational claim is submitted, this claim is submitted by the operational creditor, we have to very carefully see whether the proper documentation is there and proper supply is there, whether just it's a paper transaction or supply has happened and whether so all these things have to be seen, whether actual supply of material is there and actual billing is there. This maybe you need to check the like inflow of the material, gate passes have to be seen, and how the payment has been made has to be seen. All these things are required to be seen before you admit the claim itself. Okay. So then, of course, my numbering is not correct. 667 and all that. I'll just try to change that. 7, 8.
But that doesn't matter.
Last issue is if the resolution plan submitted by the M is approved and implemented, what treatment has to be given to bank X, NBFC Y, and supplier Z? So in the resolution plan, basically how the plan is discussed by COC and how the distribution mechanism is accepted, it would depend, and the commercial wisdom of the COC would prevail. So whether these people will get some money or not?
X is unrelated financial creditor. He's a member of COC.
Yeah. So
And
he'll
he
get
deserves
whatever as a member of COC he'll get, and if there is surplus amount, and then NBFC will also get some amount, and supplier Z will also get some amount if uh, resolution plan provides such amounts. So now, so these are some of the issues. I hope they have been useful for thinking, but it's very simple. I made instead of doing anything. Well, I've discussed the issues and the answers also here. Of course, we have discussed the answers. So, so we need not go again into this. So basically, the one I think which courts look into the real control and relationship, not paperwork. This is what, as far as NBFC is concerned. So we have to see whether proper documentation is there, proper loan agreement is there, and then the repayment has happened in a regular way, and then EMIs have been fixed or not. So all these things have to be seen before saying that a loan is a loan. So these are some of the things we have already discussed. Let me see. And undervalued transaction, and then prove a loan is extortionate transaction. This also is, I think people have mentioned this. Provisions of whether they'll get any money, provisions of section 53 apply to them. No favorable or adverse treatment is there. So this is one case which I thought we'll just try to clarify. And then now that we have some time, I'll take another maybe 10-15 minutes to I have a small set of questions which maybe we can consider. It's a small quiz I've made. So the answers maybe you can give, or answers. I'm not provided the answers directly because I think people should be able to decide which is the correct answer. But I can give you the answer if required. So the first question, let me the quiz, and either you can put your in the chat box, or maybe you can mention it here. The exclusion of related party financial creditors from COC is best described as. So this is like what kind of a policy it is. Whether it is a punitive policy, arbitrary, policy-driven, temporary. How do you describe within the four descriptions? Somebody can mention or somebody can put it in the chat box.
It's policy driven. It's policy driven. Authorized bond,
Policy,
policy driven, sir.
Yeah, I also go with
policy-driven.
policy
Yeah.
driven.
Yeah. Because it is not punitive and it is not arbitrary because there is some basis. A policy driven basically because if you see, IBC in India has decided that we'll exclude the. There are other geographies like in UK or we mentioned and all that. There is sometimes they allow the people to be part of COC. And then maybe voting is differential voting or maybe voting is not allowed. How much of voting is allowed? These are all matter of a policy. So policy decision will be the most appropriate answer. Next question is, which doctrine is central to identifying related parties under IBC? So there's some doctrines I have mentioned. Ejus dem generis, substance over form, strict construction, promissory estoppel. This
Should
is
be,
more
I
of
think
a
should be
legal.
B. Should be
B is
B.
the answer. So answer can be easily guessed. That is not a problem. It is uh, D. Somebody is mentioning is a D. No, D is
It's
not the
B.
answer.
B
Promissory
for
estoppel is
Baldwin.
not there. It
B
is
for
substance
Baldwin.
over form.
Yeah.
Substance over form is the correct answer. Now let's
Because you have to identify control, influence, and economic reality.
exactly, sir. That's very true. Very true. Uh, Number 3. A related party financial creditor may attend COC meetings but cannot vote. Of course, we know why. The question is why. Voting is linked to security. Voting is linked to debt size. Voting implies control. Voting delays CIRP.
Voting
Which
implies
is the more
control. C.
C is the correct answer.
AG,
Because you know,
can I attend the COC? Can I attend the COC?
no, he cannot attend the COC.
Yeah,
Related party financial may attend the COC meetings, but no. I think the question is not correct that way.
exactly,
May
exactly.
it is not. He cannot attend also because
Yeah.
participation is also not allowed. Representation, participation, and voting, all the three are not allowed. So he cannot attend. I stand corrected. So, but the basic idea is that voting gives control over the matters, decision making is involved, and so he cannot be part of the decision making process. Then, fourth question is, which
29A.
provision primarily prevents promoter re-entry? Promoter re-entry, there are different questions. Re-entry, of course, um,
29A.
yeah. 29A prevents submission of a resolution plan. Section 21 says that no, you're not uh, eligible to be a member of the COC. Section 25 is given. Let me see. 25 is duties of resolution professional. I don't know why this option is given, but just to be able to confuse only. Section 53 is a distribution mechanism. So re-entry of promoter is prevented by section 21 and 29A, but more accurately 29A. Now let's go to next question. Which transaction attracts a 2-year look back period? A preferential transaction with unrelated party, operational debt repayment, related party preferential transaction, any secure transaction.
C.
So which is the answer for the
C.
related
Related
party?
party professional
Uh, Related
privilege.
party professional transaction is C is the
Yeah.
correct answer because in this case we are talking about a 2-year look back period. In it's a preferential transaction with unrelated party, it will be 1-year look back period. But may I ask, most of you have handled CIRPs in experience. There's 1 year, 2-year period. Is it sufficient for a look back?
Not at all, sir. It should be
So,
more. It should be longer.
Actually, there is one
yeah.
more dimension to this because
Hmm.
once the petition is filed in the court, so it
Yeah.
takes long time in admission of the case, and then
Yeah.
it becomes skeptical from which date this look back period is to start. Ideally, it should
Correct.
start from the date of the application, not from the admission. But the law provides it from the date of admission. So between
Admission.
the period the application is filed and the case is admitted, maybe 1 year, 2 years are lost. And during this period,
Yeah.
so many things may happen actually.
Yeah, very true. What you say is very right. But in fact, I say there is something more also because the filing of application in IBC itself is so much delayed compared to the default period. Because the account becomes bad, becomes NPA in a bank or otherwise also. And after that, 2 3 years, banks especially spend a lot of time in going to SurfaceE, and then if nothing works in SurfaceE, they come to IBC, which should not be the case. But because they are banks are more interested in recovery rather than rescuing the company. So this 2 year look back period becomes very very short period, and there are mostly transactions beyond 3 years, 4 years sometimes. Of course, in fraudulent transaction you can go back, but then it is very difficult to fix as a fraudulent transaction because the definition is also uh, it is like a sieve. You can escape there in so many ways.
especially especially if such transactions are periodical in nature.
Very true. Yeah. Yeah.
Over the years, every month, met to a
Mm.
maybe a fake transport company.
Yeah. Yeah. Correct. Correct. So periodic payments have been making, and so over a period, it is very difficult to say it is a fraud. So, so it's very difficult, and especially the treatment of the courts when PUFE application is filed, they don't take it up, and then when if at all they take it up, they take so much of time, and then they don't decide on the particular transactions. So I have come across, maybe I'm wrong, but only one case of clawback I've seen. That is that Jay Prakash infra case, Jel Jil, what they say that where the mortgage has been reversed. That is a big case which is decided by the Supreme Court. But very rarely I find some decisions on, of course, one or two decisions in Bangalore also I've seen. I'm from Bangalore, by the way. But generally, very difficult to get any decisions on this PUFE transactions. Okay, now let us move to the next question. In Phoenix ARC, creditors were excluded because they were unsecured, they lacked independence, loan was interest free, and charge was defective. Four
It
reasons.
should
Of course,
be,
I have not
it
given the
should be
full.
B actually. Others can be checked
uh,
out.
yeah, generally, I mean, you can kind of elimination. You can decide which is the correct thing. They lacked independence because they were working in consort with the corporate debtors, promoters, and all that. So it is very difficult. So the answer is they lacked independence. So that is the conclusion we can come to. Next question is IBC's treatment of related parties differs from Companies Act. I discussed this why it is differing because it focuses on compliance, focuses on disclosure, focuses on insulation from influence, focuses on shareholder democracy. This is slightly confusing,
I
but
think
answer
C
can
should
be
be the
guessed.
answer.
Sir?
Yeah, C.
C, C.
C is the answer because IBC related parties have to be insulated. They have to be separated from influence, and their influence should not be there in the proceedings of CIRP. So C is the correct answer. Related party creditor in liquidation. By the way, I should disclose this quiz is generated by ChatGPT. Anyway, just I thought it's useful to discuss. Then I thought I included it.
Yes, yes. Sure.
Um, a related party creditor in liquidation. A related party creditor in liquidation is barred from recovery, gets lowest priority, is treated like any other creditor in waterfall, is paid only after disclosure shareholder. So which is the correct
C.
interpretation?
C.
A
C should
related
be
party in liquidation.
Get
C
lowest
is
priority.
Yes, C is the right answer.
C is the correct answer because he will
C.
not get, he is treated like any other creditor in waterfall. So he gets a lowest priority, that is wrong. He is barred from recovery, that is also wrong. And he is paid only after shareholders. Incidentally, I came across one case of NCLT Chennai. It is Ravi scans or something like that. I did not include it for discussion here. What it says, the NCLT says is that the related party unsecured loans is more like a equity only. It has to be treated as equity. That is what the interpretation in that particular case is there. It has to be treated as equity. And then, as such, the related party should get lower priority compared to other unsecured loans, other operational creditors, and all that. This particular decision was there, which was surprising because I don't know, because even though it is not provided in Section 253 in the waterfall mechanism, but the court has said that this is provided in UNCITRAL original bill, original model bill. They say that no, unsecured loans by related parties is more or less similar to the equity. I don't know whether anybody is familiar with such an
No,
interpretation,
no,
but
no, no, no. It can't be equity. It can't be equity.
I know it. I mean, see, there is an element of truth in that, saying that suppose you take an unsecured loans. Most of the companies you find unsecured loans from friends and relatives, or the promoters themselves. They would, instead of raising as equity, they would give a loan. But such loans are almost similar to equity. But this has not been recognized in the waterfall mechanism, and then there is no clause which says that unsecured loans by friends and relatives should be given a lesser priority. But there are one or two cases I've seen where priority is being given, but priority has not been given to related parties. But going by the decision of the Supreme Court in one case where they said Section 53 has to be strictly seen and it is not to be influenced by the relatedness of the parties. So I did not include the NCLT cases in the this list in the presentation. But there is one case of Ravi Scans NCLT Chennai. Maybe you can see that uh, that gives a different interpretation to unsecured loans from related parties. Okay, now next question is security created for holding companies loan creates financial debt. Security created for holding companies loan creates a financial debt only if charge is registered, interest is paid, disbursement is to corporate debtor, loan agreement exists.
I
See,
think
the background of this question is that what I mentioned in that Jayaprakash Infra, where the Infra is a subsidiary of Jayaprakash Enterprises, and they had given mortgage of their own properties to the loans given to their holding company. So the holding company, all these banks who have given loan against these properties they said that we have to be included as COC members. There was a lot of
I
dispute
think
on this. It's an old, very important case and very big case. Maybe 2019 or 20 or something, maybe 21. I don't remember the exact year. But where RP said there is no time value of money, there is no direct disbursement. You cannot. You have just given a mortgage, and you have given mortgage. You have given a loan against the mortgage, not against the as a loan agreement.
I
So
think
then,
the D should be
since
the
there is
answer.
no, sir, yeah, C is the answer. So since a direct disbursement to the corporate debtor has not happened, whether they should be treated as the Supreme Court has decided that where the mortgage is there and no other direct loan has been given, they will not be treated as members of COC. So that is the answer. C is the answer. Now, number 10. The overarching objective behind the excluding related parties in IBC is to penalize promoters, increase litigation, preserve fairness and value, and speed of liquidation.
That's also
Has to
C.
be C only.
See.
C, obviously C it is. So these are some of the questions I thought we'll just tickle our brains before we break for lunch.
Sir, I have got
My
one question to ask you. This is not
sir,
related to. I have something, some advice to ask you. It's not related to our topic today.
which
As you
one,
know,
sir?
in liquidation, going concern concept has been withdrawn. There is no going concern sale nowadays.
Yeah,
So
true.
if I am selling,
That
if I am selling under slump sale,
yeah,
can I transfer the company to the buyer?
when you transfer the company to the buyer in liquidation, that's what you're saying.
Exactly, sir. Because there are some licenses, some clearances, all in the name of the company only. So the
Yeah.
person who will be buying the machinery and all that,
Mhm.
they will not be able to exercise their. Again, they have to go for new ones.
Yeah, correct. No, actually, this sale in liquidation itself is getting. I think they are dropping that clause now in the coming amendments and all that. A lot of discussion was going on in that.
They have already dropped. They have already dropped.
No, but sorry to interrupt. I think, in my opinion, one can apply to the NCLT and get approval from them. In this case, uh, we'll be getting better price, and
Yeah,
the company also, and the interest of other stakeholders also is protected better. So I think in most cases NCLT might be positively inclined. That is what I think,
very right.
Even I do
even
agree
if it
with
is
you,
not
sir.
there.
Because that is already lost. If the company goes to dissolution, everything will go to dustbin.
Even if it is very rare, even it is 1 out of 100, but in my opinion also there is nothing wrong in going
No,
for it if the option is already there.
no, sir. It's not 1 out of 100. It will be much more.
It
Because
will be
only,
much more. It will be
yeah,
much more. But I'm saying if suddenly something comes up,
yeah. Suppose there is
that
planted
some
machinery.
buyer comes up that okay, I'm ready to uh, whatever in this condition as we discussed.
So normally, in case of
Right.
planted machinery, if if you don't apply this, then all will be scrapped.
Yes, the
Correct.
value also will erode like anything.
Exactly, sir. Exactly.
No, basically the question of sale and liquidation comes only when in CIRP we are not able to get a buyer to take over the company as it is. So probably there is some difficulty in taking over the company as a whole, the company totally, and then running it. So that's why it goes into liquidation. And at that point, very difficult that you get a similar proposal like resolution plan in liquidation. I mean, on paper it is possible, but then on generally I find it. I don't think it has, but I have no information whether such things are actually happening. We
Then, sir,
don't
what?
know much.
Then, sir, why they have kept slump sale?
Yeah,
Why
slump
the?
sale is there. Yeah,
Yeah,
slump sale is there, but uh, the slump sale will be even lesser than what you would get in a CIRP
that,
through resolution plan.
that is true. They could have deleted slump sale also.
Mm,
There
mm.
are four modes of sale. An assets
Yeah, true.
on a standalone basis, asset sales collectively, asset in parcel. And now
I
they
Yeah,
have
think
included slump sale.
the modifications are being proposed in order to speed up the process because of such options, the process was being delayed
yeah,
inordinately.
correct.
Under exceptional circumstances, I think we can always convince the NCLT.
Yes, sir. That
Yeah,
is the only way now
true,
left
Mhm.
true.
to get a good
Because
value.
sometimes it happens that the right buyer, it has not come to the notice of the right buyer because of any
But
No,
that is
actually, I've
the
seen, especially in real estate transactions, I've seen some projects. They are not able to take up and run it as a project. But then people would like to buy the property, especially land is there. They would like to buy in liquidation because they can. Whereas if you want to take over the project, and run it, then a lot of like cost overrun will be there, and then home buyers will not pay extra money. All these difficulties are there. In such cases, people prefer to take the property in liquidation.
It was already there. Then why they
It
dropped
is there.
provisions?
Yes, sir. Yes.
And
So my presentation ends here.
yes, sir.
If any particular issue is there, maybe we can discuss that relating to related parties. I hope it has been useful to you,
Of
just as
course,
a
of course.
revision. Yes, sir.
Of course, sir. It is very nice.
Yes,
Thank
it
you very
was
much.
really good. Thank you. Thank you for a very good presentation.
Thank you, sir. Thank you very much. So, Madam is there, Anjali Madam. Shall I close?
How long is the break?
So I think Anjali Madam will let us know.
Yeah, 1 o'clock is my session ends, and then I think 2 o'clock the next session will start.
Okay.
Yeah, shall
Okay,
we?
sir. With that, I'll close.
Can anyone
Uh,
call Anjali Madam?
I'll just see if I can call her. Let me see.
I'm here only.
Yeah, yes, ma'am.
Can we conclude now?
So, yeah,
Uh,
we
when
can
are we
close the
meeting
session.
again? That time we wanted.
Pardon, sir?
When are we meeting again post lunch? Everyone
Sir,
wants to
now
know.
there is lunch till 2 p.m. Second
Uh-huh.
session will start at 2.
Two. Okay, okay. Okay, that's all.
Thank you very much, sir. The session was very interactive and wonderful. Sir, you are
Yes, ma'am.
requested to kindly share the presentation.
Thank you very much, ma'am. Thank you very much. I'll end it here.
Thank you so much.
Thank you.
Anjali ma'am will log in with the same link.
Yes, ma'am, the link is the same.
Okay, thank you so much.
Better to.
Shall we log out or no need to log out?
No,
Don't
no, no
think
need
only.
to log out. You can log in and next session will start in the continuation.
Okay.
Thank you. Thanks for your participation, and I'm really thankful that you people joined. Thank you very much.
Okay. Any other questions in this? I would like to. Okay. Thank you, Risha. Thank you for your confirmation. Thank you so
So shall we start?
Good afternoon, Anjali.
Good afternoon, all. Welcome back after the lunch. Now the session will be taken by Shravan Vishnoi sir on the topic role of authorized representatives under IBC. Let me briefly introduce Shravan sir. Sir is CS registered valuer and IP registered with IBBI, and he is enrolled with Bar Council of UP. Sir is highly qualified professional with deep understanding of IBC. He has been a member of ICSI IIP, demonstrating his commitment to continuous learning and professional development. Sir is currently a managing partner at Stoller Resolution Professional LLP IPE. He is having experience of over 20 years in the area of insolvency, liquidation, corporate management, valuation, restructuring, compliance, governance, taxation and due diligence, audit and law. Now I request sir to start the session on the topic role of authorized representative.
Thank you, Anjali ji. Am I audible?
Yes, please, you are audible.
Yes, sir. Please continue.
Thank you, sir. I first of all, I offer my gratitude and thanks to the ICSI IIP, IBBI, and I will welcome here all the participants for this a very good topic. I will explain the role of the AR in the insolvency resolution process of the CD. I am sharing some slide here to begin with. Yeah. So in the today's discussion, we will be discussing about the AR, the legal provisions which govern the AR, its role, duties, responsibilities, the rights of the AR in the COC meeting, casting of the votes, pre-meeting, post-meeting, before the COC meeting, the accountability, power, limitations, some of the case laws which uh, have the bearing on the authorized representative. So today's topic time has been fixed for 3 hours. So we will try to cover all the provisions, all the regulations, sections within this prescribed timeline. First of all, if I'm having some problem in screens, so just a moment, please. I'm on. Yeah. So before going into this, let us first understand why this authorized representative and when it was basically introduced, specifically after the pioneer urban matter. So to go into the background of this recognition of the home buyers as a financial creditors. As you know, before home buyers, before 2018, the home buyers were not recognized as the financial creditors. So this was the Pioneer Urban Land and Infrastructure Limited versus Union of India. Honorable Supreme Court held that home buyers are the financial creditors. Section 5, subsection 8 and clause F of the IBC, which defines financial debt. And the definition starts that the financial debt to include any amount raised under a transaction having the commercial effect of a borrowing. So the 2018 amendment, 2018 amendment clarified that amount raised from allottees under the real estate projects fall within this definition. Consequently, the home buyers qualify as a financial creditors under section 5 subsection 7 of this code. So this statutory recognitions basically entitled home buyers to initiate the corporate insolvency resolution process or proceedings under section 7 of the IBC to participate in the COC meeting. So this pioneer urban matter basically gave the entitlement to the home buyers to be recognized as a financial creditor. This was the judgment which by which the legal position that the home buyers are not merely consumers but are the stakeholders with enforceable rights under the insolvency regime. So this was the background how due to this pioneer urban matter, the home buyers were given the title or status of the financial creditors who can initiate insolvency proceedings under section 7 of the IBC. So now we will see who is the authorized representative under the IBC. So as you can see, the AR is the registered insolvency professional who is basically appointed to represent a class of financial creditors in the CIR. In this regard, what is relevant is section 21. Section 21, subsection 6 and 6A deals the provisions regarding the AR. And this role of AR was introduced in the Second Amendment Act 2018. While the IBC does not specifically define the authorized representative in the IBC in the main text, the section 21(6), section 21(6)A, regulation 16A, regulation 24, sub-regulation 5 are certain regulations or sections which find mention the role or about the role of the authorized representative under the insolvency and bankruptcy code or under the CIRP process. Why is the role of AR critical in the insolvency cases? If we can see, we have mentioned in basically 4 points here. One is unified voice of creditors. You see, there are thousands of home buyers in the real estate matters, hundreds or thousands of deposit holders or the debenture holders, where the company has issued the fixed deposit receipts or taken the FDR or issued the debentures and raised the fund. So the AR role is here to consolidate the inputs from the entire class of creditors who are financial creditors under the IBC. And if all the creditors are entitled to present or represent or place their voice in a meeting, what will happen? It is not possible to conduct a meeting smoothly. So, to give the unified voice, consolidate the inputs, have the proper proceedings of the meeting, effective representations before the COC meeting, and to avoid any chaos, this AR provision was deemed to be very effective. That is why this provision came into place. I'm sorry. Enhanced operational efficiency, second point. In a COC meeting, a streamlined coordination is necessary. Each COC members have specific rights and everybody has to be properly represented. So, on behalf of the class of creditors, if a person who is qualified, who has the understanding of the process and all, is given the recognition to represent, authority to represent, then there must be an enhanced operational efficiency. That is why the role of the AR is critical in the insolvency matter. Then we can say, for practical purpose, it is necessary that creditors' participation by a proper individual who has all the logical aptitude is maybe represented, and transparency and accountability is the last but not the least, to establish a clear communication channel between the RP, between the other members of the COC, vis-a-vis the class the AR is representing before the COC. The role becomes very critical in the insolvency matters. In the brief, we have mentioned here that there are certain provisions or sections, regulations which deals with the legal provisions about the AR. So the first is section 21, subsection 6A of the IBC. Just a moment. One moment, please. I'm providing the link to my associate for proper presentation of this slide. Give me one moment, please. Now, yes, sir. Thank you. It's fine now. So, section 21, subsection 6A. So, if you see the section 21, the relevant provision in respect of authorized representative has been given in subsection 6A, which prescribes that, this is on the screen, where a financial debt, there are three clauses basically, ABC, where a financial debt is in the form of a securities or deposits, and the terms of the financial debt provides for appointment of a trustee or agent to act as AR for all the financial creditors. Such a trustee or agent shall act on behalf of such financial creditors. So, in case of APSI, where the debentures are issued or the company has taken the fixed deposit, there are many, or you can say the large number of the deposit holders or the debenture holders who are there. Since all are the financial creditors, they need to be represented by certain people, because all cannot represent in a COC meeting. So this is the case of the deposit holders and the debenture trustee. So this 6A subsection of section 21 clearly specifies that such trustee or agent shall act on behalf of such financial creditors. So they will be representing their class in the COC meeting. If we see subsection B or subclause B of 6A, it is mentioned or it is prescribed that where a financial debt is owed to a class of creditors exceeding the number as may be specified, other than the creditors covered under clause A or subsection 6. So this seems to be clause A of subsection 6. The IRP shall make an application to the adjudicating authority, means NCLT, along with the list of all financial creditors containing the name of the insolvency professional other than the interim resolution professional to act as their authorized representative, who shall be appointed by the adjudicating authority prior to the first meeting of the committee of creditors. So this Subclause B of 6A of section 21 specifically deals with the class of creditors who are the home buyers, we can say. And the clause C of this 6A section 21 prescribe that where a financial debt is represented by guardian, executor, or administrator, such person shall act as an authorized representative on behalf of such financial creditors. And it further says that such authorized representative under clause A or clause B or clause C shall attend the meeting of the committee of creditors and on vote on behalf of each FC to the extent of his voting rights. So after reading this 21 6A, we can see that it establishes the comprehensive framework of the authorized representatives' appointment, powers, and responsibilities in representing creditor class within the CRP regime. This section was basically introduced to ensure that large group of creditors can be effectively represented in committee of creditors. So we have seen the subclause A and B. If we see this subclause A and B, if we can see the clause B, which says that the financial debt is owed to a class of creditors exceeding the number as may be prescribed, as may be specified. So what is the number which has been specified? To find out the answer, we have to refer the circular of the IBBI, which was issued on 13th July 2018. I'm alone. Can you share the circular? Please share. Please share the circular. No, it is not there. मैं stop कर दूं क्या? Share again. So can someone confirm whether this screen is visible? Because this is very, very relevant circular to
Yes,
understand.
Yes, it's visible.
Yes. Thank you, sir.
Hello, am I connected? I can't hear anything.
I also can't hear anyone actually.
Okay, okay. I thought I got disconnected.
Oh, I'm sorry. I'm sorry.
It's
I'm
all right.
sorry. Uh, it was actually mute. I'm sorry. So I'm just repeating it, whatever I've said just now, that by this circular dated 13 July 2018, it prescribes all about the authorized representative, which was mentioned in section 21, subsection 6A, clause B. So it says that section 21, 6AB of the IBC read with regulation 16A 1 of the IBBI, Insolvency Resolution for Corporate Persons, Regulation 2016 as amended, provide that where the corporate debtor has at least 10 financial creditors in class. So it means where less than 10 home buyers are there, it is not required to be appoint an AR because the limit prescribed it is 10. If the financial creditors in class are at least 10, then the interim resolution professional shall offer a choice of 3 insolvency professionals. From among us 3, professional and a creditors in the class may indicate its choice of an insolvency professional who is the choice of the highest number of creditors in the class. So what does it mean basically? Where there are at least 10 creditors in that particular class are there, the IRP shall select at least three number of insolvency professionals, and the choice will be given to the creditors in that class to select any one of the 3, and the highest number of the IP who has been given the choice shall act as the authorized representative for particular that class. It further says that the AR collects voting instructions from the respective class of creditors, attends the meeting of the committee of creditors, and cast vote in respect of said class in accordance with the instructions he receives from the creditors. So this is the brief of the para 1 of this. The para 2 of this circular says that section 21, subsection 6AB of the code, read with the regulation 16A of the regulations, provide for a very simplified mechanism of representation of financial creditors through authorized representative as detailed in para 1 above, and therefore matter of a procedure. It is necessary that an ongoing, this is regarding the ongoing CRP. So this is 2018 circular. This is not important. So I am just lefting it out. And 3 is also I'm lefting it out. So now coming to the main part of this particular circular. You can share the slide. So accordingly, we have discussed here how this subsection 6A of the section 21 deals with the appointment of the deals with the enabling provisions about the AR. Anything? Is there any doubt about this, or anything we want to understand on this, or we will move further? Is it fine, sir? Any confusion or anything which is not clear about it? Because there is nothing like this is not clear, but still I am asking. No, next. Now we will be dealing with the regulation 16A. Regulation 16A, which speaks or which outlines almost everything regarding the AR, has prescribed certain key provisions are there. So we will be reading one by one. We will be discussing one by one. First is there, which says that the interim resolution professional is duty bound to select the insolvency professional who is the choice of the highest number of the financial creditors in the class in Form CA received under sub-regulation 1 of Regulation 12 to act as the AR of the creditors or respective class. So what is this Form CA? Basically, if you remember that in the insolvency resolution process, we as an IP has to give the public announcement within 3 days of the commencement of the CIRP. In that public announcement, IRP has to give the name of the at least 3 insolvency professionals in case the corporate debtor is of such nature, such class, where appointment of authorized representative is necessary. So this basically Form A, a public announcement into the insolvency resolution process, which deals with the intimation of the CIRP and asking the creditors to submit their claim. So in this claim requisition, you can say the financial creditors in class has to submit the claim form in Form CA. And in that Form CA, the financial creditors in that class has to select at least one insolvency professional out of the choice given by the IRP in the form itself. 3 names are required to be given for each class. Then it says that IRP has to select the one who has been selected by the highest number of the financial creditors in that class. So this is the duty of the IRP to select one who has received the highest number of choice. Then it subsection 1 also further provides that the choice of the insolvency professional to act as an AR by the FC in Form CA shall not be considered if Form CA is received after the time stipulated in the public announcement. So, as you know that the creditors has to submit their claim within prescribed time, and after that prescribed time, some financial creditors in class has submitted that form and has selected certain individual as IP out of the name of the IP given in the form itself, then that form shall not be considered by the IRP. So time is essential here by to be adhered by the financial creditors while submitting this form CA. Subsection 2 of the, or you can say subclause 2 of Regulation 16A, which prescribes that the IRP shall apply to the adjudicating authority. So first thing is that the IRP will find out the name of the three, publish into the public announcement. Then the particular class of creditors will select one out of three, submit the form CA with the IRP. Submit the form with the IRP, then IRP will verify the form and do necessary things. And after that, subsection 2, subclause 2 of 16A regulations prescribes that the IRP within 2 days of the verification of the claim under the relevant regulations, and the regulations is 12, shall apply to the Honorable Adjudicating Authority for appointment of the authorized representative selected as per sub-regulation 1. So whosoever got the highest number of choice, the IRP is duty bound to submit an applications within 2 days of the verification of the claim before the Honorable NCLT for appointment of the authorized representative, and the application shall mention the name of the insolvency professional who got the highest number of choice by the respective class of creditor. And the proviso to that subsection also specifies that if the NCLT does not approve the application which is filed by the IRP, and pending application, the person who has been selected to be appointed as the AR, he will continue to act as an interim authorized representative. So likewise, IRP, where the appointment has to be confirmed by the COC in the insolvency matters, the application could not be approved or it is pending before the NCLT, then that AR will continue to act as an IAR, interim authorized representative, pending disposal of such applications. And this proviso also specifies that the person who is acting as an IAR shall be entitled to attend the meeting, act in accordance with the provisions of the code, like cast the vote, attend the meeting, and do all the things which are required to be done. And it also specifies that the delay in the appointment of the AR shall not affect the validity of any decision taken by the committee. So it also specifies that whatever the situation circumstances are there, if there is any delay, then committee may take the decision accordingly. That decision of the committee will not affect by the reason of the delay in appointment. So these sub clause 1 and 2 of regulation 16A, which specifically deals with the AR, has prescribed the procedure for appointment or selection of the AR by the particular class of creditors and appointment by the NCLT. Then if we can see sub clause 3A. Sub clause 3A of the 16A regulation says that or prescribes that the financial creditors in class representing not less than 10% voting share may seek replacement of authorized representative with the insolvency professional of their choice by making a request to the interim resolution professional or the resolution professional who shall circulate such request to the creditors in that class and announce a voting window open for at least 24 hours. So basically, subclause 3A of regulation 16A prescribes the procedure how the AR shall be replaced. Sorry. The replacement of the AR is not the subject of the committee of creditors. The replacement of the AR is the subject of that particular class of creditors. If that particular class of creditors are not satisfied, or that particular class of creditors who have appointed the AR feels that some other insolvency professional can better represent them before the COC, then 10% members of that particular class who are having the voting share may request the IRP to arrange for replacement of the AR. And the insolvency professionals of their choice may be appointed by that particular class of creditors. Then I think the RP will be duty bound to present that application for confirmation before the Honorable Adjudicating Authority for giving effect to that decision. So 3A of clause 3A of regulation 16A prescribes about how the replacement of the AR will take place. Then another clause under regulation 16A is given, that is the 3B. 3B specifies that subject to clause A and B of sub-regulation 2 of regulation 4A. The IRP or the RP, as the case may be, shall offer choice of at least 3 insolvency professionals to the financial creditors in the class, including such insolvency professional proposed under sub-regulation 3A along with the existing authorized representative. So this I explained in detail. Then 3C, subclause 3C is there, and this subclause 3C
Actually,
specifies about.
sorry to interrupt, the slide is not moving. Is it happening
I-
at my end only or with others also? I don't know.
Okay. I'm just removing the slide here. Slide move नहीं कर रहा है ना, इसको हटा देते हैं. ठीक है. So I'm just explaining the provisions of this section. So it is better than you can display the provision of that sections to understand the. I'm sorry, and thank you for pointing it out. I'm displaying the provision of the section. Yeah, perfect. It is fine. So I was explaining the sub-regulation 3C of regulation 16. I hope it is visible to everyone. If it is not, kindly point it out. The regulation sub-regulation 3C of regulation 16A prescribe the resolution professional shall apply to the AA for appointment of AR who receive the highest percentage of voting share of the absent class. So this I have already explained how this appointment happened. Then we can see sub-regulation 4. Sub-regulation 4 prescribe about the list of creditors, and it says that the IRP shall provide the list of creditors in each class to the respective AR appointed by the authorized by the AA. So here the duty has been cast on the insolvency on the IRP to provide list of all class of creditors to the AR. Then sub-regulation 5 cast and duty on the IRP and provides that the updated list shall be provided as and when updated by the IRP. This updated list shall always be provided to the AR. One thing is very important here to understand. In the matters, in the real estate matters, basically, the list of creditors used to update frequently. And if someone has handled the assignment as an AR, he must be receiving the complaints from many home buyers that their claims have not been updated, or they could not the file claim in time, or they need the assistance in filing of the claim and all. So one clarification has been given in subclause 5 of regulation 16, which you can see here, that the authorized representative shall have no role in receipt or verification of the claims of the creditors of the class he represents. So basically, the AR has to make distance from receiving any of the claims or the role in verification of the claims. It is the duty of the IRP. It is the duty of the particular creditors in class to submit the claims within the prescribed time to the IRP, and IRP will verify the claim as per the procedure practices established here. So one thing AR has to very very well aware that he has no role in verification and receipt of the claims. Then subclause 6 is there. It says that the AR shall be provided with the electronic means of communication to interact with the particular class of creditors. In some cases, the AR by himself used to provide the platform for interactions, and what platforms may be available for interaction with the particular class of creditors. Those may be the virtual meeting uh, platforms like Zoom, Gmeet, Teammeet, etc., or some other software where the video conferencing or means of communication is available. Primarily, it is the duty of the IRP to provide that means of communication to the AR. AR in turn will interact with the home buyers. Then section clause 7 prescribes about the voting share of the creditors in class, and it says that voting share of creditors in class shall be in proportion to the financial debt, which includes an interest at the rate of 8% per annum unless a different rate has been agreed to between the parties. So before this, there was 61. This was introduced in it was introduced. There was certain confusion actually before this was given, that what rate of interest to be charged on such financial debt. So it is specifically specified that 8% shall be the rate of interest which shall be charged for the amount or the specific contract or agreement between the parties. So whatever the rate of interest is there, that will be the rate of interest eligible for calculating the voting share. Then sub clause 8 is there. Sub clause 8 prescribes about the fee of the AR. If you can see that the AR shall be entitled certain fee for every meeting of the committee entitled to by him, it is there in the following manner. So basically the fee which AR is received in any of the matters, basically the fee of the meeting only. There is no other remuneration prescribed for the AR. Before this amendment, the fee was different, and after this amendment, this amendment was happened in September 2023. September 2023, the amendments came into place, which revises upward the fee of the AR in attending the meeting. So the fee has been prescribed based on the number of creditors in the class. The first slab which is prescribed here, that is where the number of creditors in a class is 10 to 100. Then the minimum fee or the maximum fee which is prescribed here, that is 30,000 rupees per meeting. and where the number of creditors in a class ranging between 101 to 1000, it is 40,000 per meeting of the committee of creditors he attends, and where the number of creditors are more than 1000 in any CRP, then the maximum fee the AR can get 50,000 per meeting of the committee. After that, there is another type of meeting which the AR has to attend or convene. That is the meeting corresponding to the meeting of the committee of creditors. So this clause 8 subclause B of regulation 16A prescribes that the authorized representative shall be entitled to receive fee for every meeting of class of creditors convened by him in the following manner. So the number of creditors in the class has been fixed same as that of the meeting of the creditors. So 3 slabs have been prescribed: 1, 10 to 100, then 100, 1 to 1000, then more than 1000. So in case of meeting corresponding to the COC meeting, fee per meeting of creditors in class with the AR has been prescribed 10,000 in case the number of members are up to 100, and 101 to 1000 it is 12,000 only, and more than 10,000 members are there, then the fee will be 15,000 per meeting corresponding to the meeting of the creditors. So it means that the AR can have the meetings with a fee for any COC meetings with the creditors in class are two meetings. One is meeting prior to the COC meeting, and another is the meeting post holding of the COC meeting. So these two meetings, for those two meetings, the AR will be entitled to get the fee as per the prescribed amount. Sub-regulations 3 also prescribes that the payment of fee to the AR shall always be the CIRP cost in respect of two meetings with the creditors he represents corresponding to the meeting of the committee of creditors. Then question arises, what if the AR holds more than two meetings? For this, clause 8 subclause D of regulation 16A specifies that the fee for any additional meeting beyond meeting or beyond two meetings corresponding to the meeting of the committee of creditors shall be form part of insolvency resolution process cost subject to approval of the committee of creditors. It means for two meetings, there is no approval required by the committee of creditors. This will be deemed as the CRP cost. But if as an AR you hold third meeting, and if you wish to charge the fee of that meeting, do not forget to put up that agenda through IRP or RP before the COC meeting for their approval. Before this amendment 2023, the fee prescribed for the meeting of the committee to be received by the AR was 15,000, 20,000 and 25,000 range, depending on the number of the creators in class was there. So this was just doubled after 2023. Subsection 9, subclause 9 of regulation 16A prescribes about the pre-meeting conditions, which says that the AR shall circulate the agenda to creditors in a class and may seek their preliminary views on any item in the agenda to enable him to effectively participate in the meeting of the committee. So to fulfill these obligations, which is cast upon the AR, the concept of pre-meeting has been prescribed, and accordingly, every AR has to convene a meeting of the creditors in that class before the attending the meeting of the committee of creditors. And in that meeting, he has to discuss the agenda which shall be taken up by the committee of creditors in their meeting. For that purpose, the AR has to convene the pre-meeting, send the agenda, actually hold the discussions of the meeting, seek the advice of the committee of creditors of that particular class, and put up their views as per the instructions he had in that pre-meeting.
Sir, is it mandatory to conduct this meeting pre and
Yes,
post COC?
you can say yes, because if you see the sub clause 9, which is in front of you, the AR shall circulate the agenda to creditors in a class and may seek their preliminary views on any item in the agenda to enable him to effectively participate in the meeting of the committee. If you are not convening the meeting of this particular class of creditors, then how you will effectively participate in the meeting without having their views? As an AR, if you are attending the meeting of the COC, you have to put up their views, correct?
Right, sir.
And if you have not convened the meeting, then how you can say that you have the proper instructions or preliminary views? Then, although the may word is there, but to my view, it is mandatory to convene the meeting.
Sir, but if the preliminary views are sought through email or other electronic modes and not through a meeting,
That you can do, sir. But see, there are certain class of creators where if you can see that there are 10 to 15 members are there, right? And only 10 to 15 members are active. Then you can seek the view through email also. But I'm talking about where the large number of creators are there and very important item is going to happen in the COC meeting. It is always advisable to convene the meeting to avoid any charge on the AR that no, he has not performed his duty and all. It's advisable. Although it is not mandatorily written that he has to convene the meeting, but it should be.
okay.
This is my view. But circulation of the agenda is mandatory. Meeting may call, but as in my cases, I used to call pre-meeting always. And if you are not calling the meeting, then you are making yourself into the loss, because for that meeting, certain fees is prescribed also. You are, if you see sub-regulation B, 8B, which is there. The AR is entitled to get the fee for at least 2 meetings corresponding to the COC meeting. So for COC meeting, if you are not convening the pre-meeting, then you will not be entitled to this SLAO fee for that meeting. So it is advisable to convene the meeting. For that purpose, you will be getting the fee as well as you will be getting the mandate in writing. Correct? You are offering the thing. I think it is clear now. Now move to the sub clause 10. Sub clause 10 prescribes about the authorized representative duty. The AR cell, let us discuss one by one. The AR cell assists the creditors in a class he represents in understanding the discussions and considerations of the committee meeting and facilitate informed decision making. So how you will do that? How as an AR you will assist the creditors in class you are representing in understanding the discussions and considerations of the committee meetings and facilitate informed decision. Until you are not interacting with the particular financial creditors in class, how you will ensure this? This may happen with the pre-meeting and post-meeting. Subclause B, review the contents of the minutes prepared by the RP and provide the comments to the RP, if any. So as you know that after every meeting, the minutes are circulated by the IRP, then it is the duty now because the AR cell, it is the duty to review the contents of the minutes which are shared by the RP or IRP. And if there is any comment on that minutes, you as an AR has to inform the RP. Then subclause C, help the creditors in class he represents during the consultations made by the RP to prepare a strategy for marketing the assets of the CD in terms of sub-regulation 1 of regulation 36C. Can you share this regulation 36C1? So the regulation 36C, which is the strategy for marketing the assets of the CD, sub-regulation 1, which says that RP shall prepare a strategy for marketing of assets of the CD in consultation with the committee, where the total assets as per the last audited balance sheet, last available balance sheet, not audited, last available balance sheet, exceed 100 crore rupees and may prepare such strategies in other cases. वापस आ गए. So in cases where as per the last available financial statements, the asset size of the CD are more than 100 crores, then the RP shall help the creditors in class during consultations made by the RP to prepare a strategy for making the assets of the CD in terms of reverse. D. Work in collaboration with the creditors in class he represents to enhance the marketability of the assets of the CD in terms of regulation 3, in terms of sub-regulation 3 of the regulation 36. So here also he has to work in collaboration with the RP as well as the creditors in their particular class. How the maximum value can be faced in framing all these strategy, he has to work in collaboration with the FCs and the RP. E. Assess the creditors in class he represents in evaluating the resolution plan submitted by the resolution applicants. So, the resolution plans are submitted by the RAs and the FCs who are member of the COC, and if it is the class of creditors, they may not have that much of understanding about the reading, about the evaluation of the plan. Then the AR must consult with the creditors in their class he is representing and have the good amount of discussions among them, make them understand what is the plan, what is the I'm sorry, what is the plan, how it can be negotiated, what are the clauses which may be modified, what are the things. So all these must be fairly made understandable to the creators in their class. Sub clause F, that is very important clause. This casts a duty on the AR, and it says that the AR shall ensure that the creditors in a class he represents have access to any information or documents required to form an opinion on issues discussed in the committee meetings. It says that members of the committee of creators who are basically creators in class, they must be given access to all the important information. So now it is you who have to see what are the informations which required to be circulated, which required to be make available, which required to be given to the particular class of creators so that they can make specific submissions, they can understand what the matter is basically. So you have to be very cautious about providing all those informations, and sufficient information must be provided to all the members of the COC whom you are representing. Subclause G, which provides that update regularly the creditors in class he represents on the progress of the corporate insolvency resolution process. So if you basically see that in any of the CRP, it is a very time-bound process, and until there is no stay on the process rolls in a very, very time-bound manner. Every CRP process, from invitation for claims, then resolution plan, then negotiations, particular other transactions, valuations and all. So this process supposed to be end within period of 180 days. So in every meeting, you have to represent your class of creditors, and the progress of the entire CRP has to regularly update to the financial creditors in class you are representing by way of meeting or whatever means you deem it fit. H. make suggestions for modifications of the resolution plan as may be required by the creditors in class he represents. So here, in case of there is a plan, then you have to make the suggestions for modification of the plan if your class of creditors requires so. Then record proceedings and prepare minutes of the meeting with the creditors in class he represents. This is also a very routine or important work which as an AR you have to ensure that all the proceedings of the meeting are recorded, minutes are prepared and circulated in the prescribed manner. And the last point, which is mentioned in subclause 10, that is act as a representative of the creditors in class he represents in representations before the AA, NCLAT, and other regulatory authorities. So it mandates that as an AR, you have to represent your class in before the various authorities. Subregulation 11, which is also there, it says that the provisions regarding minutes of meetings in this regulation shall apply for clause 1 of subregulation 10. 1 I ऊपर थोड़ा record proceedings and prepare minutes. So whatever provisions for the minutes are there, you have to ensure for the meeting of the AR also. Next item. And next 12. 12, you can say it is a residual clause, which says the creditors in class may propose any additional responsibility upon the authorized representative in relation to the representation of their interest in the committee. So it says very openly that the creditors in class may propose any additional responsibility upon the AR in relation to the representation or their interest in the committee. What will be those? Or no, although everything is specified here. Now, next. The 16 is over. The next what we have to 25 is. Now we can come on to the slide. Huh? स्क्रीन कर सकती हूँ. Yes, regulation, section 25A. Now, after we have seen the regulation 16A, which was there, described all the procedural aspect. The section 25A deals with the rights and duties of the AR. It says that if you can see the sub section 1 of section 25A, it says that AR under subsection 6 or subsection 6A of section 21 or subsection 5 of section 24 shall have the right to participate and vote in the meetings of the Committee of Creditors on behalf of the financial creditors he represents in accordance with the prior voting instructions of such creditors obtained through physical or electronic means. Shall we take 15 minutes break now?
Yes, that will be good.
Yeah, no? Then we will continue other part and after 15 minutes break. It will be good. Thank you. So we will be joining after 15 minutes. Thank you.
आप वेजिटेरियन है या नॉन वेजिटेरियन? नॉन वेज। नॉन वेज। ठीक है, ड्रिंक करती हैं या नहीं करती? नहीं करती। चलिए मान लीजिए आपकी ऐसी जगह पोस्टिंग हो जाती है जहाँ खाने पीने के नाम पर आपके पास एक ही ऑप्शन अल्कोहल कंज्यूम करना। हाइपोथेटिकल क्वेश्चन है, ऑब्वियसली
Okay, thank you. So we will again starting or resuming.
Yes, sir.
Yes, sir. So after this regulations, we are basically prescribes the rights and duties of the AR. So if we can see this sub section 1, which prescribes that AR under subsection 6 or subsection 6A of section 21 or subsection 5 of section 24 shall have the right to participate and vote in the meeting of committee of creditors on behalf of the financial creditors he represents in accordance with the prior voting instructions of such creditors obtained through physical or electronic means. So it basically casts an obligation on the AR in terms of that the AR must take the instructions for participation in the COC meeting regarding their views, and that instructions can be in physical or electronic means. Those instructions can be obtained through physical or electronic means. So basically, as an AR, the role is more or less to represent their particular class before the meeting of the committee of creditors. In the CRP process, the committee of creditors is the authority which approves the resolution plan, which approves the CRP cost under the directions of the COC. The RP is acts to further to achieve the object of the court. So AR, before attending the meeting of the COC, used to convene the meeting of the particular class of creditors and seek instructions and accordingly represent them before the committee. Subsection 2 of 25A prescribes that it shall be the duty of the AR to circulate the agenda and minutes of the meeting of the committee of creditors to the financial creditor it represents. It means whenever the agenda is circulated by the IRP or RP, the same agenda must be further circulated to all the members of the COC the AR is representing for their knowledge. And after that, the AR should convene the meeting of the particular class of creditors he is representing, have their views, detailed discussion on the agenda of the meeting, consult the financial creditors, and accordingly participate in the meetings of the committee of creditors. So this is the pre-meeting of the CRP, pre-meeting of the committee of creditors. Basically, the AR has to do, and in the same subsection, it prescribes that the minutes of the meeting of the committee of creditors shall also be circulated by the AR. So after the committee of creditors meeting is over, whenever the AR receive the minutes from the IRP RP, he has to send those minutes to the financial creators, the class whom he is representing. Subsection 3, which says that the AR shall not act against the interest of the financial creditor. He represents and always act in accordance with their prior instructions. What does it basically means? The AR who is appointed to represent the particular class of creditors is supposed to act for the benefit of that class, in the interest of that class, and in accordance with the instructions or advice, whatever he receives from that particular class of creditors. This subsection further provides that if the AR represents several financial creditors, then he shall cast his vote in respect of each financial creditor in accordance with the instructions received from each financial creditors to the extent of his voting share. So here you can see that one AR acting for the two class of creditors or for the separate class of creditors. So in that scenario, he has to cast his vote he has to cast vote on behalf of that particular class of creditors he is representing. This subsection further provides that provided that if any financial creditor does not give prior instructions through physical or electronic means, the AR shall abstain from voting on behalf of such creditors. So, if there is no such instructions, then he must not exercise his discretion over particular item, and he must abstain on such a decision where no specific instructions have been given by the particular class of creditors to the AR. Subsection 3A of section 25A prescribes about this clause that which specifies like this: notwithstanding anything to the contrary contained in subsection 3, the AR under subsection 6A of section 21 shall cast his vote on behalf of all the financial creditors he represents in accordance with the decision taken by vote of more than 51% of the voting share of the financial creditors he represents who have cast their votes. So this clearly mentioned here that the AR shall cast his vote where the decision has been taken by more than 51% of the votes by the class of creditors. It further provides that provided that for a vote to be cast in respect of an application under section 12A, the AR shall cast his vote in accordance with the provisions of subsection 3. Subsection 3 you have also already seen. Then next subsection is 4. The AR shall file with committee of creditors any instructions received by way of physical or electronic means from the financial creditors he represents for voting in accordance therewith, to ensure that the appropriate voting instructions of the financial creditors he represents is correctly recorded by the IRP or RP as the case may be. So here all the instructions in whatever manner he has got from particular class of creditors, he must file the same with the committee. And electronic means has been further clarified here through an explanation that by such as may be specified. So electronic means are audio visual means basically. So this is the section 25A provision. So by this, the legal provisions regarding the AR has been basically given in regulation 16A section 25A section 21 subsection 6 or 6A and regulation 24 and section 24 subsection 5 of the code. So these are the legal provisions. Now I will move forward by some slide representation. You can take it as a revision of the legal provisions or whatever we have left it here out, all will be covered in the further slides. So if you can see that this is what is the duties of the AR under IBC. So we have jot down certain duties which we are already covered under regulation 16A. All we have dealt in detail while going through the provisions of that particular regulations or section. Duties of the AR in brief, we can write here that it is to assist the creditors in class he is representing in making them understand and discuss before them in decision-making process. The AR has to review the minutes which are prepared by the RP, and if there is any modifications or there is any suggestions in the minutes, AR has to properly communicate those decisions to the RP. Then we can say that the AR help the creditors whom he is representing to prepare proper strategy of marketing the assets of the CD. AR has to work in collaboration with the creditors whom he is representing in marketing the strategy of the marketability of the assets of the CD. And AR basically assists all his creditors in evaluation of the resolution plan. This evaluation of the resolution plan is a very vast area because the resolution plan in itself is a very big document which is supposed to be compliant or drafted in accordance with the provisions of the IBC. The creators in class who are very much concerned about their financial proposal, what they will be getting in the resolution plan, what is the best they could get from the plan, all evaluation, all modifications, negotiations, all the things has to be easily understandable to the financial creators in class is representing, and it plays a very vital role for the AR to present all these things to their class of creators. The AR has to ensure that all their creditors in class must have access to the entire set of informations which are required to discuss, to frame opinion by that class of creditors or take decisions by that class of creditors. So providing the information, access, making easily accessible to all those informations, it is one of the most important duty of the AR. The AR is supposed to update the entire process, the progress of the process to their class of creditors. AR also has to make suggestions for modifications of the resolution plan whenever it is required to the class of creditors. In respect of meetings of the AR with the home buyers, the AR has to record the proceedings of the meeting, circulate the minutes of the meeting in the class he is representing, or the minutes of the COC meeting has to be circulated in a very time-bound manner, and voting facilitations shall also be made through the AR. So these are the primary duties of the AR. Recently, the one of the major duty has been prescribed under this code, and that duty is to act as representative for creditors in a class he represents before the various authorities. So, by the introduction of this clause, see earlier the before this clause was not introduced in the code. Earlier, the role of the AR was just to participate in the COC meeting and facilitate in voting. But the role of the AR has now been enhanced to great extent. Whatever duties and responsibilities has been cast upon by under this code on the AR, it is enormous. If the particular class of creditors who are being represented by the AR wish that AR must represent or may represent before the Honorable Adjudicating Authority in appeal or before any other authority, this is the duty of the AR now to represent before the authorities on behalf of the class of creditors whom he is representing. Let us take an example. Suppose there is some decision by the Honorable NCLT, and by that order, the financial creditors in class feels that it is not in their favor or they are aggrieved by the order. And if that class of creditors wish that particular order may be appealed or should be appealed, they may advise or they may ask the AR to prepare to get their matter represented before the appeal authority. And in that case, the AR shall act as a representative before the Honorable NCLAT if it is the case like that. We can take another example where the particular class of creditors wish that certain application may be filed before the adjudicating authority, then AR has to file the application based on the wish of the that class of creditors. But all these things are subject to the procedure and practices and law prescribed here. It is not that anything and everything should be represented. AR being qualified insolvency professional, AR having the knowledge of the entire process, the nature of the business of the corporate debtor, he must put up all the facts and figures before the financial creditors, class of creditors he is representing, before going into this matter of representations. So this is very important point which is inserted. Now let us discuss about rights of AR in COC meetings and voting process. As the right of the AR before the COC meeting, the AR is the member of the committee of creditors on behalf of the financial creditors he is representing. So by that virtue of representation power, the AR has full right to represent their class of creditors before the COC meeting. So accordingly, he has all the rights, including right of speaking, asking questions at the COC meeting, casting votes on behalf of the class of creditors. This includes the right to attend and, of course, actively participate in the COC meeting, explanation seeking, expressing the concerns, present collective views of the creditors. So here the AR shall be in full role as a member of the COC in the same footing as other members of the COC are representing their particular member. We can, through an example, can understand that in a COC meeting where there are different banks who have given financial assistance to the CD, and they on the basis of the claims, those banks or financial institutions having specific powers in terms of voting share. At the same time, the AR who is representing maybe the deposit holders, maybe the home buyers. So the AR whom he is representing must bear in mind that he is full-fledged member of the COC. He has all the rights to effectively put up the concerns of their class of creditors. He has to act in accordance with the instructions he already have to represent, to put up at that particular meeting. Then next, we can have the aggregated voting power. The voting power are basically the major point where the decisions of the particular committee is taken. The higher the voting power, higher the say in the particular process. The voting power which are exercised by the AR is not an individual but consolidated in nature. Whatever the votes which are cast by the AR is the combined instructions of the creators in the class, and he has to cast his vote based on the decisions already taken by the particular class of creators through e-voting, and the AR on that basis has to vote as a member of the COC on their behalf in that particular agenda item. The information access, the rights of the AR. This is the one of the major rights. AR has all the rights to get the informations, because until he is not getting the information, how he will perform his or discharge his duties effectively. So he must ensure that he is having all the documents, informations. He also has to devote appropriate time on going through all the documents and informations so that the particular class he is representing is properly made available access to all the informations. And strategic influence in case the unified voting rights are there to the AR, then the collective impact of the voting is there. Now, one more important point which we can discuss in details, the eligibility criteria of the AR for the purpose of appointment. So duty and rights and all we have already discussed here. Now we can see that the professional registration. So the AR, as you know, must be an insolvency professional registered with IBBI. The requirement of registration of the AR before the board is known to everyone. So one thing is that the AR who is proposed to be appointed must be registered with IBBI and must having the valid AFA at the time of this proposition and at the time of registration also, because there are certain matters which are still going on this point. You can see that at the certain point of time, one particular person may be having the AFA, but at the time of appointment before the educating authority, his AFA may be suspended or may be expired. So one has to see at the time of submission of his name or proposing his name to the RP or IRP about the appointment, then he must be having both the registration and AFA valid. Then class size threshold is there, also there. You must ensure that at least 10 members or 10 creators are there in that particular class, because section 21 subsection 6A through notification has prescribed this 10 members or 10 creators class, 10 creators number for the purpose of appointment of the AR. Then trustee or agent role. So this is the AR can be a trustee or agent appointed under the consortium agreement and all. And selection process is this: the IRP shall propose the 3 names of the qualified insolvency professionals, and out of these 3, the person who is getting the highest vote, he has to be appointed as the AR. So appointment process is like a revision that filing of the application before the Honorable NCLT. Then NCLT giving the note to the AR. Creators voting. Creators within the class can cast their vote as per the selection. Then official appointment. The AR is formally appointed by the AA, and the voting coordination, the appointment of the AR collects voting instructions from the all the creators. Another point which I can discuss here, that any member of the committee who is having the voting right may appoint an insolvency professional as his representative. So the banks or financial institutions who are the financial creditors having the right to vote may on their behalf appoint the authorized representative to represent himself or itself before the COC meeting, and for that purpose AR is authorized to be appointed on their behalf. Then we have pointed out certain distinction between AR and RP. As you can see here, what AR actually does, AR represents a specific class of financial creditors. AR has the limited role focused on the representations and voting within the COC. AR acts as a representative for creditors' interest whom he is representing and appointed to give voice to large creditors group. Whereas the RP manages the entire CRP process. RP always acts as a neutral facilitator for all the stakeholders, because he is not representing particular class. He has to make a balance of among all the stakeholders, all the creditors. The RP is appointed by the committee of creditors or NCLT to conduct CRP process. The role of the RP is much wider than AR, because the RP has to verify the claims, manage debtors' assets and all. What is provided to the AR? AR must not receive or indulge into the verification of the claim, just to avoid conflict of opinion between the RP and the AR. Now we can revise the remuneration of and expenses of the AR. Whatever the cost of the AR in terms of fee as prescribed under the regulation 16A shall be the CIRP cost. Whatever not prescribed here anywhere, it has to be specifically approved by the COC to become the CRP cost. So only 3 costs have been prescribed. One is for attending the meeting of the COC, and other the 2 meetings of the AR with home buyers corresponding to the particular COC meeting. So only 3 meetings fees he may get. For any other fee and expenses, if the AR has to charge, it must be approved before by the COC to form the CRP cost. Regulation 16A, Sub-Regulation 8 and Clause A and B of the regulations prescribe the fee structure, as I told, and this framework ensures that the professional who is representing as an AR must be respected and valued in the entire CRP process. Now, AR's accountability and limitations, although we have covered while discussing particular section 25A and 20 and regulation 16, but still, for the sake of revision, we can see here that what is the accountability standard. So AR is accountable to both the class of creditors and the honorable adjudicating authority, ensuring dual oversight and responsible conduct. The dual accountability mechanism ensures transparency, responsible conduct, and the objectivity adherence to the IBC. Good faith, power, limitations. So this one can kept in mind that the COC decisions cannot be override or act beyond instructions received from the creditors. So AR must ensure that he must not acting at his own. He must adhere whatever instructions he has received from particular class of creditors. And the AR role is very limited to represent of their class of creditors only. He must not take independent decisions. He also must not over resolution passed by the COC or exercise his discretion in any of the matter. He must act within overall corner of the law mandates he received from the particular class of creditors. Now we can discuss also the role, critical role of the AR in IBCs. So AR must have the proper understanding, enhanced efficiency, unified voice, and balanced framework. So these all are the characteristics. We will not go into this. And representation in the committee of creators, we have seen this, but for the again for the purpose of clarity, let us see that AR serves as an official voice of that class of creditors only whom he is representing, like home buyers or deposit holders or the debenture holders. By consolidating all the wisdoms or views of the particular class, he must ensure that he is representing effectively within the advice given and must not override their wisdom. So वो शेयर नहीं हो रहा है स्क्रीन sorry. Then we have already discussed. So voting we have taken, there is no protective minority test. So we will discuss this in brief. That in insolvency proceedings, dominant stakeholders with larger financial stakes can potentially override the interest of smaller creditors. Sorry. The AR serves as a crucial safeguard against such imbalances. You are aware that the member who is having the greater voting share in the COC may override the interest of the other creditors who are not having the proper or adequate voting percentage. So the AR must provide legitimate platform to raise objections and concerns of the class he is representing. He must be very vigilant. He must have all the characteristics of a good negotiator, or he must present the interest of their class in a very effective manner so that their interest may be protected even though they are not having the proper voting rights, voting shares in the COC meeting, so that the class whom the AR is representing must not be override by the other class of creditors, other creditors who are having the maximum voting percentage. So this is the very uh, first ability of the AR must exercised before the COC meeting. Then what are the challenges which are being faced by the AR in the process? First, selection often occurs through IBBI or creditor consensus with limited transparency, raising questions about representation's legitimacy. So, brief it. The RP has to select three names of the insolvency professional of his own choice. And out of these three, only one has to be selected by the particular class of creditors in Form CA. Then the person have who got the highest choice is the AR. So always questions arises why not the creditors have been given their choice of selection of name. Why the names from all these three names which the uh, IRP or RP has proposed. So this always open a questions before the stakeholders. Then resource constraint, limited financial resources and specialized expertise to effectively represent large diverse creators group with varying needs. So again, this is a very very challenges before the AR because of the limited financial resources. Then conflict of interest risk, it is always there because there are courts and stakeholders where they may face this scrutiny, and accordingly the challenges is essential for strengthening the AR framework and ensure the effective. Now we can open the question answer. But we all have discussed all these things. Cases we already discussed. One case I have not discussed, we can discuss here. This JP matter in brief. In JP matter, when this JP दिखा दो, stop करें. So in this JP Infratech matter, One clarification was issued by the IBBI because of certain ambiguity was there. If you can see section regulation 16A sub regulation 9, can you see 16A sub regulation 9? (16A9), which says that the AR shall circulate the agenda to creditors in a class and may seek their preliminary views on any item in the agenda to enable him to effectively participate in the meeting to the committee. So because of this, this clarification says that several emails have been received by the board from some financial creditors in a class, namely home buyers, expressing confusion about the manner of voting in context of resolution plan in the CRP of JP Infratech Limited. It appears that there is internal voting or pre-polling on certain matters which are not in the agenda before the committee of creditors. So this prima facie does not appear to be in consonance with the. So what had happened in that matter? The AR has floated certain agenda or like pre-polling, internal voting before the actual resolution plan. So IBBA has to come out with circular that see whatever agenda is there, whatever voting will be there, that voting has to be pre-voted by the FC in that class, and on the basis of the decision of that particular class, AR will vote. So this was clarified. That is why this JP case was important. Now we can discuss the question answer and open house for clarification. So some MCQs just for sake of understanding and little interactive. I have prepared this. I hope everybody is vigilant here and will take part in this process, this MCQ. Just to check our knowledge also. Question number 1. Under which section of the IBC is the appointment of an AR or class of creditors governed? There is no fear of wrong or right, just to make it very interactive and test our knowledge or update our study. This I have shared. Certain questions are there so that we can test our knowledge. B, section 18, 21, 6A, section 25. If we can be interactive by voice, then it will be over. Then this will be okay. Section 25, section 30. So what is the correct answer? As per you, sir, anyone? Section 21, 6A. B answer is correct. Thank you. Somebody is right. So is very update. Who is eligible to be appointed as an authorized representative AR? The options are any financial creditor of the class, practical legal advocate, registered insolvency professional, and suspended management of the directors. So this is C, basically. C, right? Because only insolvency professional can be the AR. Then 3, how many IPs must the resolution professional RP
3.
in the public announcement? Form G नहीं है, form गलत लिखा है, form G, form A होगा. Form G for the creditors of AR. In 3, very correct answer, sir. Thank you. Then we can check our knowledge Is the AR required to act strictly in accordance with the instructions mandated received from the creditors they represent? No, only, yes, only. What will be the correct answer of question number 4? The answer is yes. He must work under the instructions he received. Next, we can check our knowledge. 5. If 60% by value of the home buyers in a class instruct the AR to vote yes on a resolution plan, how does the AR cast the vote? 60% as yes and 40% as no, or 100% of the class voting as yes, the AR abstain from voting, AR follows the decision of the. What will be the answer? Answer will be B. Correct, sir. Mr. Gagan, very, very correct. So we will, as an AR, we will vote as 100% as yes. Next. 6. थोड़ा नीचे आ रहा है, थोड़ा नीचे, थोड़ा ऊपर.
Before the NC.
Can an AR represent the class of creditors before the NCLT for facilitation of the unit of registration? So this is very important questions. Please read it twice. I also have to read it twice because I'm not knowing the answer of those questions. Can an AR represent the class of creditors before the NCLT for facilitation of the unit of registration? No, only the RP has the power to file such IA, yes, for collective interest and to avoid multiplicity of the litigation. C, only if company is already in liquidation. D, only if AR is also member of the local.
B should be the option.
Yes, sir. Correct. B shall be the option if they collectively are next. Before receiving the IM from the RP, what must AR submit? Performance and guarantee, undertaking, list of creditors, or waiver of their professional fee.
List of creditors, Aadhaar numbers.
Before receiving the IM from RP, what must AR submit? Yes, undertaking, confidentiality must be submitted by the AR.
Confidentiality undertaking.
Then, in large real estate CRP, what is the primary administrative task of the AR office or oblique IPE? Question number 8. In large real estate CRPs, what is the primary administrative task of the AR's office oblique IPE?
Thousands of meals.
What will be?
Just B.
B, correct, sir. B is the right answer. Next.
The professional fees of
professional fee of the AR attending the meeting is treated as part of the
B.
CRP for B, correct. 10. What should an AR file a representative IA instead of individual buyers filing 200 separate applications to maximize the AR billing hours, to maintain judicial discipline and sub the tribunal's time, to because individual buyers are legally barred from NCLT. What is this? ABCD लिखा नहीं है उसमें. लिखा है? ठीक है. हाँ. B. Correct, sir. B. Next. Can an AR share a short note or summary of the information memorandum with a class of creditors?
B. No.
Correct.
Which
correct.
one?
B is correct. Yes, provided it is to be enable them to provide an informed voting mandate. B is correct, sir. Next. In which specific scenario is the majority of those who voted rule not applied by the AR? Approval of the plan, appointment of liquidator, approval or for withdrawal of the CRP application, and approval of the valuation matrix. 12 ka. In which specific scenario is the majority of voted rule is not applied by the AR? Sir, in the withdrawal applications, that is C number, this majority rule will not apply. Next. under regulation 16A,
Yeah,
which
sure.
is the primary factor determines the AR's professional fee for attending each
The number
COC
of
meeting.
times.
Total value, number of hours, number of caterers within the class,
D
and
for Delhi.
percentage of voting share. Oh, sir. Please read the question. Under regulation 16A, which is the primary factor that determines the AR fees? That is the number of caterers, sir. 0 to 10, 10
Yeah,
to
yeah,
100, 1000 to 1.
yeah.
Yes, sir. Next. 14. An AR is prohibited from being an advocate, having conflict of interest with the CD, representing more than one class of in the same CRP, or attending virtual meeting from the remote. So what will be the answer?
B.
B. Correct, sir. Next. If the RP refuses to provide registration of home buyers in possession despite a prior NCLT order, what is the ER's correct legal course? This is very practical question.
Filing place commands the RP.
C.
If the RP refuses to provide registration to home buyers in possession despite a prior NCLT order, what is the AR's correct legal course? Filing an IA under success defect. Correct. C number. 16. How soon must an AR circulate the minutes of COC meeting to the creditors they represent? Within 12 hours, 48 hours, 5 days before the
48
next
hours.
meeting. Correct, sir. Next. For the AR to cast the entire class vote as yes for a resolution plan, with what majority by virtue is required among those who cast a vote? 33, 50%, more than 50, 66.
For the
Sir,
AR to cast
थोड़ा tricky है सर, थोड़ा क्वेश्चन ध्यान से पढ़िएगा.
for the AR to cast the entire class. Yes.
D.
D for Delhi.
सर 66% COC के अप्रूवल चाहिए, लेकिन अगर मैं AR हूं और AR को वोट करना है तो हमारे क्लास ने अगर 50% से ज्यादा वोट किया है, then we have to cast as yes. So answer will be C.
C.
Next. Which body is responsible for taking disciplinary action against the AR for professional misconduct? COC and C. कोई doubt नहीं. IBBI is the body. Next, the AR argues for equitable treatment primarily to ensure that all caterers get 100% their money back. Similar situation caterers, RP fees are reduced. The original applicant is the related party.
B.
argue for primary to ensure that all caterers get similarly situated creditors. B for Bombay.
Correct, sir. Logical answer. Next. Can an AR appointed as the liquidator of the CD? Big no. हो सकता है सर?
Be appointed as liquidator of the corporate.
ये कहीं नहीं था, ये मैंने वैसे ही बनाया है.
Yes.
सर लिक्विडेटर वाला वैसे भी कंट्रोवर्सी है, अभी नया बिल भी आ गया है, और वैसे AR तो अगर COC चाहे तो लिक्विडेटर तो बना ही सकती है, कोई ऐसा इशू नहीं है.
Definitely. In
66%.
that, I think in that situation, he will have to relinquish his role of an AR.
Role of?
The authorized representative.
Sir, because liquidation once passed, then the role is already over. And in that case, if COC desires, then he can be appointed as the liquidator. And ultimately, the appointment of the liquidator is by the NCLT, the applicant. So B appears to be a good answer.
नए बिल में क्या है सर?
नहीं, नए बिल में जो सर आया है ना, उसमें तो कहा गया है कि लिक्विडेटर नहीं हो सकता आरपी। आरपी नहीं हो सकता, एआर की बात नहीं कर रहा हूँ, आरपी नहीं हो सकता, क्योंकि यार हाँ, नए बिल में ये था। नेक्स्ट 22, filing a representative IA by the AR served to prevent multiplicity of litigation and ongoing. See, correct. So there are many questions. I think, shall we continue or shall we conclude the session? I think time is 50 minutes is remaining ना. हाँ, ठीक है, चला दो. Creditors in class must provide what to the AR before receiving summary of the IM. Repeat. आंसर नहीं बताया 23 में. ऊपर आओ.
Creditors in class must provide what is the confidence.
Undertaking, sir.
Right.
Next. What is the standard duration allowed for creditors to provide voting instructions to the AR? 12 hours, 24 minimum, and exact 7 days, any other time NCLT approves. What will be the? We have just gone through na, that 24 hours window.
Yeah.
So item is, so answer will be B. Next. Does the AR have the right to negotiate with the resolution applicant in a negotiation meeting? No, only FC banks can negotiate. Yes, as member of the COC representing a substantial voting bloc. Only if AR is chartered accountant. Only if negotiation is about unit price. Does the AR have the right to negotiate with the resolution applicant in negotiation meeting? Sir, it is B. Yes, as the member of COC representing a substantial voting bloc. So as a member of the COC, he can negotiate, but this must not override the wisdom of the financial creditors whom he is representing. He must have come with the very specific directions from their class of creditors. Then it is B. Who is responsible for verifying that the AR themselves is fit and proper and eligible under IBC? Home buyer, CD, IBP and IP, and the local police.
C.
C. Correct. Next. RP often cite the Section 14 moratorium to justify not facilitating registries. The AR counter argument is usually the moratorium does not apply to home buyers. Units and possession are outside the state and registration is a contractual completion. The moratorium is unconstitutional. The AR has the power to be moratorium. What is the correct answer, sir? B. Correct, sir. Because in cases where the units are already in possession, he must facilitate, and the recent amendment is also there. Next. How can a class of creditors replace their authorized representative? By simple email to the RP, by physical protest at the NCLT, by an application to the RP with 33% voting share, followed by vote and NCLT approval. C. Correct, sir. Next. Why a regulation 46A of the liquidation regulation relevant to an AR during CRP? Its set of the RPs. Please read all four. The answer is B, sir, because 46A or always argument is there. The position, the units which are already in position are excluded from the liquidation state. Next. Is an AR personally liable for the debt of CD? Yes, no, only. So answer is clear. AR is not personally liable. B is correct. Next, which schedule of the CRP regulation provides the code of conduct binding on the AR? फर्स्ट शेड्यूल, सेकंड, थर्ड, फोर्थ, ये थोड़ा सा ऐसा क्वेश्चन जो किसी को याद नहीं होगा जब तक शेड्यूल ना पढ़े. तो आंसर इज ऑल्दो आंसर इज ए, शेड्यूल, फर्स्ट शेड्यूल. नेक्स्ट, रिपीटेड छोड़ दो. Why must the RP office offer 3 IPs for selection as AR? To increase the RP paperwork, to provide a class with democratic choice, because one IP might be busy. It is requirement for all IP appointments under IBC.
D. D for Delhi.
Next, Section 21(6)(a) was introduced primarily to handle cases of creditors who are B. Next, the AR is often described as a bridge or messenger because
B.
correct, sir. Next, we are shortly winding up, concluding our session. The only 3-4 questions. Does the AR have a vote in appointment or replacement of the RP? Yes, as
A voting member
voting
of
member of the COC. Answer is B. Next, age registry. Sorry. What does an AR utilize insolvency professional and why does an AR utilize an IPE services basically
distributors or resources for message.
to leverage institutional resources for massive data handling and investigation. But in certain CRP, there may be massive data handling. So in that case, that's right. So with this, I thank you all the participants, all the seasoned professionals for be with me and bear with me for this session. Thank you so much. Anjali ji, if you are here, then you may.
Thank you very much, sir.
Thank you so much,
Session was
sir.
very interactive.
Thank you, Anjali ji.
Sir, if you have any PPTs, kindly share.
Excuse me, sir. When we will
Yes.
receive the certificate of this participation?
By Monday.
Okay.
Thank you so much, sir. Thank you so much.
Thank you, Anjali. Thank you.
Thank you.
Thank you.
Thank you very much, sir.
Thank you, sir.
Thank you.
The person you have called is speaking to someone else.